Constitution Review Committee, we started the discussion on the judiciary in the last half of yesterday's engagement with a presentation by Samson, who placed before us a number of interesting issues pertaining to the judiciary, but also in relation to certain provisions of the fundamental human rights chapter. We will devote the entire day today to looking at the judiciary. We have received numerous submissions on this particular cluster, and we are fortunate to have one of those submitters in the person of Professor Stephen Kwakua Asare to make a presentation from his location in the state of Florida. Kwakua Asare needs no introduction. He is probably one of the, I don't know how to describe him. He's a serial plaintiff, a serial plaintiff or serial petitioner before our Supreme Court. And the cases that he has brought before the court have made interesting case law and spawned a whole jurisprudence in some of these areas. I once actually thought of having a book titled The Asare Cases, and having assembling a number of academics to do a review of each of those cases, compilation, and then review those cases. So he's no stranger to us when it comes to matters of the judiciary. One of the interesting things I've noted about the 2010 and 2011 report of the Constitution Review Commission set up by Professor Mills at the time, that in the period since that report, among the interesting things that have happened since, which that commission did not have the opportunity of those developments when it was doing its review, but which we do. Among those are some very interesting things pertaining to the judiciary, which is that since that report, we have had 2 presidential election petitions go to the Supreme Court. Since that petition, we have had the removal provisions of Article 146, which cover both Superior Court judges as well as non-judicial independent constitutional office holders triggered successfully once. And since then, we have also and currently also seen petitions for the removal of the Chief Justice, all of which puts the judiciary pretty much on the spot. Afrobarometer surveys before the election also, and even before that, have showed dwindling public trust in the institution of the judiciary. So these are all concerns that were not necessarily before the last Constitution Review Commission. And so I think it's given our commission a lot more to chew on in terms of, interest, heightened interest in the judiciary, and for that matter, in the subject matter for this particular engagement. There are a number of issues when you go through the submissions. The Supreme Court, of course, sits at the apex, and its composition and size are issues that have been raised. The scope of its jurisdiction, including its review jurisdiction, have also been commented upon, including by the Constitutional Review Commission in 2011. The Office of the Chief Justice has come into focus, administrative powers of the Chief Justice, and how that might impact the decisional independence of judges, not only on the Supreme Court, but throughout the judicial system, having regard to the CJ's concurrent headship of the Court of Appeal and the High Court, and his or her role in the appointment of lower court judges. The composition and role of the Judicial Council, the mode of appointment of the Chief Justice, Supreme Court judges, Court of Appeal judges, and High Court judges, and tenure and removal provisions pertaining to the superior courts. There's also been, but not a lot of focus, on the lower courts. And I think I observed yesterday that while the interest tends to be on the superior courts, the fact of the matter is that for most Ghanaians, that is not where they experience justice. For most Ghanaians, justice is experienced in the lower courts, and that's where it begins and ends for most Ghanaians. And there is, when we put the spotlight exclusively on the superior courts, we tend to miss the character of justice at the lower courts. And I think it's just appropriate that at least one or two submitters have also pointed us in that direction. So there's a lot of material for us, and it's good that we have a whole day to do this. So I'll proceed to invite Professor Sari, since he's been up there in Trumpland since probably early dawn. It's about 6 o'clock or thereabouts in Florida. So if you are available, my good friend, Professor Kwekwa Sari, you may proceed.
Thank you, Chairman Prempeh, for that warm welcome to the committee. I was invited to talk about Chapter 11, which deals with the judiciary. And so I'm going to limit my talk to that chapter, although I've presented proposals on other aspects of the Constitution as well. Now, I want to structure my presentation around these 5 areas: quick background, then why the need to reform the judiciary, then a quick overview of the amendments that I'm proposing, and then we can go into the amendments and then some concluding remarks. So in terms of background, the Constitution has actually some good aspects when it comes to safeguarding judicial independence. Regarding institutional independence, the judiciary is clearly guaranteed to be a separate and co-equal branch of government. That's per Article 125(1). Judicial power is vested solely in the judiciary. It's not subject to direction or control. That again is Article 127(1). And then decisional independence is also guaranteed, because if you look at Article 127(1), it talks about judges exercising their judicial power. Those judges are subject only to the Constitution and the law in the exercise of that judicial power. And in Article 127(2)(3), they are protected from personal liability or external interference for judicial decisions. Moreover, these articles, 125, 127, the article on their tenure, the article on their removal, are all entrenched provisions, suggesting that those are foundational aspects of the Constitution. In terms of the role of the Chief Justice, he or she leads the judiciary but must respect the independence of other judges under Article 127(1). She exercises or he exercises administrative oversight, not judicial control, per Article 125(4). And then there's the Judicial Council in Article 154. They propose, or the council proposes reforms, supports judicial efficiency, and provides checks on unilateral action by the Chief Justice. It's actually supposed to be a platform for collaborative governance of the judiciary. And then we have the Rules of Court Committee under Article 157. They are supposed to make procedural rules. They are representative and expert body, not by decree. And then that article reinforces independence through collective decision-making. And then finally, there's checks on internal overreach. For instance, the Chief Justice regulations must be advised by the Judicial Council and approved by the President. I'm going to talk about some of this later on, but as I see it, that represents the current constitutional design, the key aspects of the current constitutional design. Now, with that said, why do we need to reform the judiciary? At least 8 issues. I saw at least 8 issues. First, I believe the appointment processes lack transparency. Second, I think the lack of caps on the number of justices invites court parking. Third, I think inconsistent panel sizes in constitutional cases have become troubling. Chairman refers to my appearance at the Supreme Court. Sometimes I'm appearing before 5 people, sometimes I'm appearing before 7 people. And I've always asked myself, if these 5 people make a decision, why should it be binding on the whole country when there are other justices of the Supreme Court who have not had their say on the matter? The Chief Justice holds, in my mind, excessive influence over the courts, and this may be partly a constitutional design issue, but I also think it's just the way we operate in the country. We are too eager to cede power to the heads of our institutions, even where the Constitution is clear that they lack such power. I believe the Judicial Council, which, as I said, is an advisory council to the Chief Justice, is bloated and potentially can be politicized. I think the rulemaking is weak. I characterize that as weak institutional independence in rulemaking. And then I also think we need to depoliticize the removal process of the Chief Justice, but also of other constitutional bodies like the Electoral Commission, the NCC, and so on. Now, what are the amendments that I propose? I have 8 amendments. The first deals with the appointment process. The second deals with capping the court sizes. The third deals with the panel size for constitutional cases. The fourth deals with Chief Justice role realignment. The fifth reforms the Judicial Council. The sixth seeks to reform the Rules of Court Committee. The seventh seeks to eliminate presidential approval for rulemaking about the judiciary. It doesn't make any sense to me that the president has to approve rules governing the judiciary if indeed the judiciary is supposed to be a separate and co-equal branch of government. And then finally, I want to depoliticize, or I want to reform that depoliticizes the removal process of the Chief Justice. and by extension of all members of the constitutional bodies. So let's go through the proposed amendments, 8 of them. First, I want Article 144 amended to introduce a uniform appointment process for justices of the superior courts. I agree with the chairman that our focus should not be solely on the superior court, because most of us seek justice not at the superior courts, but mainly at the lower courts. Nevertheless, I think the example that is set at the superior court has such cascading effect that if we want to control matters, we need to start the reform at the superior courts. Second, I want Article 128(1), 136(1), and 139(1) amended to cap the number of justices as follows. For the Supreme Court, I'm proposing 11. For the Court of Appeal, I'm proposing 24. And the High Court, I'm proposing 128. Third, I want Article 128(2) amended to require a minimum of 9 Supreme Court justices to sit on the constitutional cases to ensure broad deliberation. Fourth, I want Article 136(1) and 139(1) amended to remove the Chief Justice from the composition of the Court of Appeal and the High Court. I don't really even understand Article 136(1) and 139(1) when it says the Chief Justice is a member of the Court of Appeal and is also a member of the High Court. I mean, it defies common sense. I don't understand it. Fifth, I want Article 153 amended to reduce the membership of the Judicial Council from 18 to 9. Six, I want Article 157(1) amended to reform the Rules of Court Committee, ensuring that it's an expert-based rulemaking body and removing unnecessary Judicial Council influence. Seventh, I want Article 159 amended to eliminate presidential approval for judicial rulemaking, thereby enhancing judicial independence. And finally, I want Article 146(6) amended to remove presidential involvement in the removal process of the Chief Justice, transferring the oversight role to the Judicial Council. So let's go over some of them, and then maybe I can explain the rationale for why I'm making these proposals. So let's look at the current appointment process. It's in Article 144. First, it has a separate process for the Chief Justice. The Chief Justice is appointed by the President, acting in consultation with the Council of State and with the approval of Parliament. Second, there is the process for appointing other Supreme Court justices. So the other Supreme Court justices shall be appointed by the President, but this time he acts on the advice of the Judicial Council, and then he still has to consult with the Council of State and with the approval of Parliament. I'm not sure what that means. And then third, Justice of the Court of Appeal and the High Court and Chairman of Regional Tribunals shall be appointed by the President, acting on the advice of the Judicial Council. So the Chief Justice has her own way or his own way of being appointed. Other Supreme Court Justice, a different process. Then we have the High Court and Court of Appeal judges, a separate process, and so on. I propose to unify all that, and I propose this, like in Article 144, I say the Chief Justice shall be appointed by the President, but he must act on the advice of the Judicial Council. And I use the term advice in its constitutional law sense. Advice here is binding. So it's actually the Judicial Council that is making the appointment, and the President is merely playing a ministerial role. So the Chief Justice shall be appointed by the President, but acting on the advice of the Judicial Council. And I think we need bipartisan consensus on who the Chief Justice and other members of the Supreme Court are going to be. So I say with the approval of at least 60% of all members of parliament. And I'm going to use the same process or procedure when it comes to appointing other members of the Supreme Court. So Article 144, 1 and 2 could actually be merged and says the members of the Supreme Court shall be appointed by the President acting on the advice of the Judicial Council and with the approval of at least 60% of all members of Parliament. You can see that the Council of State is gone in this proposal. That's because when you look at the totality of my proposal, I have a recommendation on the Council of State. And if you haven't read my proposal, I'm going to just say quickly, I suggest that the Council of State be abolished. So you don't see it in here in any of my proposals. Whenever the Council of State is mentioned, I replace it with something else. Then finally, we go to the Justice of the Court of Appeal and the High Court. They are still going to be appointed by the President and again acting on the advice of the Judicial Council and with the approval of Parliament, except that now the numbers, the threshold for approval should be a simple majority. So summary, Supreme Court, President acts on the advice of the Judicial Council, 60% parliamentary approval. Court of Appeal and High Court, President act on advice of Judicial Council with a simple parliamentary majority. Council of State removed from the process because I suggest it should be abolished. And then what is my rationale? Well, first, I think it eliminates political influence when you remove the president directly from it, because, you know, now what I'm saying is that we should use advice in this constitutional law sense. Second, it increases parliamentary oversight by requiring 60% approval for Supreme Court. We ensure bipartisan legitimacy and simple majority for appeals and High Court. That is efficient oversight. Third, the Judicial Council has a central role. It ensures that appointments are guided by legal expertise and integrity. And then it's a balanced approach because it combines accountability with efficiency, supermajority for the top court, simple majority for others. And then it reinforces separation of powers and enhances confidence in an independent judiciary. Summary, the revised process strikes a balance between judicial independence, parliamentary oversight, and executive authority. It strengthens merit-based appointments, it fosters bipartisan consensus, and then it enhances public trust in the judiciary while maintaining efficiency in judicial appointments too. The second one is on the caps. Again, when you look at the current constitution as designed, it has Article 128(1), and that says the Supreme Court shall consist of the Chief Justice and not less than 9 other justices. Well, that's a flaw. That means we could potentially have 100 members of the Supreme Court and it will still be constitutional. That doesn't make any sense. The same thing applies to the Court of Appeal. It says the Court of Appeal shall consist of the Chief Justice and not less than 10 justices of the Court of Appeal. Well, so what is the cap? There's no cap. Any president at all can keep appointing to the Court of Appeal. And then third, we have the same thing for the High Court. The High Court shall consist of the Chief Justice, not less than 20 justices of the High Court. And then, surprisingly, such other justices of the Superior Court that the Chief Justice may, by writing signed by him, request to sit as a High Court justice for any period. I mean, this doesn't make any sense because this is saying the Chief Justice can say to a Supreme Court justice, go and sit on the High Court for 2 weeks or for 6 months or whatever the case may be. I mean, it's very poor design, and I suggest that should be repealed as well, not just in Article 139(1)(c), but equally in Article 136(1)(c), where we talk about the Court of Appeal and the Chief Justice assigning people to sit on there. So my proposed amendment will be to cap the Supreme Court at 11, the Court of Appeal at 24, and then the High Court at 128. This will prevent arbitrary expansion and then enhance efficiency. I provide the rationale. So the caps will prevent politicization. I think it's also consistent with global best practices. And I like to talk about Kenya because Chairman is very familiar with what goes on there. and he likes talking about Kenyasi in Ashanti region. But Kenya, with its larger population and almost twice the size of Ghana, caps its Supreme Court at 7 justices, its appeal court at 30 justices, and then its high court at 200 justices. So unless a case can be made that Ghanaians are so litigious that we overwhelm our superior court and we just have to have these infinite numbers, this current design makes no sense. I believe we can cap the design, and I believe we can ask the justices to be more efficient in what they do. So for instance, there's really no reason for an appellate court to always see the plaintiffs and the defendants because they decide matters of law. I mean, it should be possible for me to sit here in the US, and if I have the briefs from plaintiffs and the defendants and it's a matter of law, to decide it. I don't need to hear from them because everything they have to say, they put in the briefs, and I can read the briefs and then make a decision. Similarly, there's really no reason for every decision of the Supreme Court to rehash all the theories on jurisdiction and so on. A justice can simply say, we have jurisdiction, and then cite 1 or 2 cases. If you are interested in why they have jurisdiction, go and read those cases. But when you read the cases of the Supreme Court, about half, maybe 75%, are referring to matters that have been resolved and that have very little relevance with the current case. That can be stopped, and that's a way of building efficiency so that smaller numbers are needed to do the job. My proposal will boost efficiency and specialization, will protect judicial independence, and it will enhance public trust. So summary, a proposal to cap the numbers, cited the corresponding numbers for Kenya, and this proposal enhances efficiency, accountability, and controls court parking while aligning with international standards for judicial independence and resource management. Third, current panel rules. If you look at Article 128.2, it says the Supreme Court shall be duly constituted for its work by not less than 5 Supreme Court justices, except as otherwise provided in Article 133 of this Constitution. Note, Article 133 just adds 2 where there are review cases. And this is reasonable if we are looking at appellate cases and cases that don't have broad reach for the rest of the country. Maybe 5 should be okay. But when we are deciding a constitutional law matter, I think just taking 5, a subset of the Supreme Court, to decide a constitutional law question that binds all the country, I think that is pretty bad. And so I'm proposing an amendment that will require a minimum of 9 Supreme Court justices. And this is not something that is novel here, because if you go back into the history, Justice Redu had practice directive to this effect. And rather than practice directives, let's constitutionalize that to say that the Supreme Court shall be duly constituted for its work by not less than 5 Supreme Court justices, except that in matters relating to the interpretation or enforcement of the Constitution under Article 130, or any matter invoking the original jurisdiction of the court under Article 2.1, the court shall be constituted by not less than 9 justices. And then I give several reasons. It ensures robust, diverse deliberation on fundamental issues of governance and rights. Larger panels enhance the authority and representativeness of the rulings. Fixed minimum reduces strategic selection and potential bias in case outcomes. Most of the complaints that we hear about courts are related to their decisions in constitutional cases that everyone hears about. And so if we fix that, we are going to, put ourselves in very good position. It aligns with global best practices, and then it promotes stability in legal precedent. Over there, I say larger panels reduce volatility, fostering stability and trust in constitutional jurisprudence. And I talk about the Osei-Boating doctrine. When Dateba and Atuguba were on the court, depending on the panel that you were facing, you could, for the same set of facts, the court would say they don't have jurisdiction based on this Osei-Boating doctrine. And then the other panel refused to recognize Osei-Boating doctrine. And this was the whole question of whether one needs an ambiguous clause before one can enforce a provision of the Constitution. Dateba in Osei-Boating appears to be saying, yes, there has to be some ambiguity before there can be enforcement. And Atuguba and others said, no, there is no need for an ambiguity if all you want to do is to enforce or ask for the Supreme Court to enforce an article of the Constitution. But as it was, I mean, I appeared before that court panel seeking the enforcement of Article 25.2, because Article 25.2 says anyone at all can set any school. And to my chagrin, the court says it has no jurisdiction. And say, well, if the court has no jurisdiction to enforce Article 25.2, where do I go? Where do I go? Because I can't go to the appeal court, I can't go to the high court, and certainly I can't go to the lower court. So my question was never resolved. And that is bad that we have such concurrent practices in the same Supreme Court. So by implementing this proposal, the judiciary can ensure that constitutional cases receive the depth of analysis they deserve while promoting fairness, legitimacy, and consistency in constitutional interpretation. It ensures that significant constitutional matters are handled by a broad and diverse panel. 4, remove CJ from other superior courts. I've talked about this. There's no reason why the CJ, who is a member of the Supreme Court, should also be a member of the High Court and should also be a member of the Court of Appeal. So proposed amendment to Article 136(1), the Court of Appeal shall consist of not more than 24 justices of the Court of Appeal, or whatever the number we want it to be. But clearly this would remove the Chief Justice. And likewise, the High Court shall consist of not more than 128 justices of the High Court. So this will remove the Chief Justice from that. And then, the rationale for that is pretty obvious. The Chief Justice should focus on administrative leadership and Supreme Court duties rather than being part of the Court of Appeal and High Court. And then caps are necessary because they ensure efficiency and cost effectiveness, and then it aligns with international best practices. So summary, the proposal refines the structure of the judiciary by removing the Chief Justice from the Court of Appeal and High Court, allowing a focused leadership role at the Apex Court. Now let's talk about the Judicial Council. It plays an important function. The Judicial Council advises on judicial reforms. It supports the Chief Justice in ensuring efficient and effective justice delivery and performs additional functions assigned by the Constitution or the law. So this is a body that is created, that is important, it has a good role, and so on. But in practice, nobody seems to even be aware that we have a Judicial Council, partly because of the way it's composed, and then partly because we just have a way of deteriorating even good things, because our culture seeps into all of these things, and no matter how well we design it, there's no vigilantism. People, the citizens are not too interested in ensuring that articles of the Constitution are enforced. And if there's a breach, people just say, oh, well, they close their eyes, they drink their beers, and it goes on. But let's look at the Judicial Council. When you look at the Judicial Council in the Constitution, I mean, look at that, 18 members. There's so many people on the council. And when you have so many people on the council, nobody will be responsible for it. There's diffusion of responsibility and nothing gets done. So there's the Chief Justice, who is the chairman, the Attorney General, the Justice of the representative of the law, a judge advocate, editor of Ghana Law Report, a chief nominated by the National House of Chiefs, 4 other persons who are not lawyers appointed by the president. Can't we streamline this into a more efficient body? I believe we can. And so in my 5th proposal, I say the Judicial Council should consist of 9 members as follows. 1, a Justice of the Supreme Court, who is nominated by the Supreme Court, and that person, not the Chief Justice, that person shall serve as chairperson. There's no reason for the Chief Justice to be part of the advisory body that advises her on how to do her job. So let's remove her from that. Second, a judge of the Superior Court nominated by the Superior Court judges other than the Justice of the Supreme Court. Third, the chairman of the Public Service Commission. Fourth, two lawyers, not of the same gender, nominated through a democratic process by all practicing attorneys. Notice, I don't use the GBA because I don't think things like Ghana Bar Association should be in the Constitution. What if Ghana Bar Association is dissolved? Then what does that do to our Constitution? Rather, we should rewrite everywhere we see Ghana Bar Association a democratic process by all practicing attorneys. Fifth, two faculty members, not of the same gender, nominated by the deans of the law faculties. And then the final one, two non-lawyers, not of the same gender, nominated by the Public Service Commission. The Public Service Commission can use interviewing, they can advertise and so on, whatever process that they come up with to choose these two people. I think it will be nice. But what this does is it reduces the size from 18 to 9 members. It creates a balanced representation from the judiciary, from legal, and then also from public service. And I believe it's going to enhance efficiency and reduce politicization because as we have the president appointing about 4 members, then there's the attorney general and so on. So basically, you are introducing too much politics into the Judicial Council. What the rationale? Smaller, more efficient council. Second, you eliminate political influence because you remove the presidential appointees to ensure merit-based independent representation. Third, you strengthen professional input by adding elected lawyers and law faculty to integrate legal expertise and academic insight. Fourth, you broaden social representation by including 2 non-lawyers nominated by the Public Service Commission to bring in public interest perspectives. And then the key outcome would be a leaner, depoliticized, and more inclusive council to better support judicial independence and reform. Summary, this amendment will enhance the efficiency, independence, and representativeness of the Judicial Council by reducing its size, eliminating political appointments, and ensuring diverse professional and societal perspectives. A streamlined Judicial Council will be better equipped to oversee judicial affairs and safeguard the independence of the judiciary. The next one is the Rules of Court Committee. The current Rules of Court Committee is composed as follows. There shall be a Rules of Court Committee which shall consist of the Chief Justice, who shall be chairman, 6 members of the Judicial Council other than the Chief Justice nominated by the Judicial Council, 2 lawyers, one of not less than 10 and the other of not more than 5 years standing. Both of whom shall be nominated by the Ghana Bar Association. So there again, you see the Chief Justice going on to the Rules of Court Committee, and then members of the Judicial Council that are supposed to advise the Judicial Council going on to the Rules of Court Committee. But the Rules of Court Committee is a very specialized committee that make procedural law for the country. When you look at the civil procedure and criminal procedure, they should emanate from this Rules of Court Committee. So you need expertise, not just random people from the Judicial Council and so on going on to this Rules of Court Committee. So I'm going to amend that and say there shall be a Rules of Court Committee which shall consist of 1 Justice of the Supreme Court nominated by the Supreme Court, who shall be the chairperson, 1 Justice of the Court of Appeal nominated by the Court of Appeal, 1 Justice of the High Court nominated by the High Court, 1 Justice of the Lower Court nominated by the Lower Court. So we have the court's perspective. Then 2 lawyers and so on, but instead of the Ghana Bar Association, the lawyers shall be elected by all practicing attorneys through a democratic process. Then I want to bring some faculty members who teach civil procedure and criminal procedure into this process. So I want 2 law faculty members specializing in procedural law, nominated by the deans of law faculties, Ideally, they would nominate somebody who just doesn't teach civil procedure or criminal procedure, but who has written extensively about civil procedure and criminal procedure. And by extensively, I don't mean he's published a book. I mean, he's done research, he's thought about the issues, and he's had his ideas vetted by his peers and published. That's what I mean. And then one representative from the Judicial Service Staff Association nominated by the association. So here are some of the reasons why I believe this is important. Number one, excluding Judicial Council members for a more focused and independent body. The Judicial Council has a broad administrative and policy-making function, whereas the rules of the court committee is a specialized body focused solely on court procedures. Judicial Council members do not necessarily have expertise in procedural rulemaking, making their involvement unnecessary. This amendment ensures that only professionals directly involved in judicial proceedings. It strengthens expertise in rulemaking by including judges from the Supreme Court, Court of Appeal, and High Court. This structure ensures that procedural rules reflect rare challenges and best practices at each judicial level. Law faculty representation ensures that rulemaking is informed by legal research, international best practices, and evolving legal education. And then it enhances representation and democratic legitimacy. Allowing practicing lawyers to elect their own representatives ensures that the legal profession has a direct say in court procedures rather than being represented by bar association appointees. The Judicial Service Staff Association's inclusion ensures that procedural rules consider the practical realities of court administration and case management. Summary, this amendment removes unnecessary Judicial Council influence, enhances judicial and academic expertise, and introduces democratic legitimacy through elected lawyer representatives. The restructured committee will be better equipped to create efficient, practical, and modern procedural rules for Ghana's judiciary. The last item is regulation by the Chief Justice. So current articles on regulation says the Chief Justice why may? She has to do it, acting in accordance with the advice of the Judicial Council and with the approval of the President by constitutional instrument, make regulations for the efficient performance of the functions of the Judicial Service and the Judicial Council under this chapter. This is such an important article. There are too many times in our country where we allow people who are given power to just exercise power that they have not published, even when the Constitution is telling them you have to do this by constitutional instrument. That is what rulemaking is all about. They just get up and then they issue a directive that contravenes the Constitution in very violent terms and undermines our democracy. Nevertheless, let's look at how we can reform Article 159. My idea would be the Chief Justice shall, I remove the may, acting in accordance with the advice of the Judicial Council as reformed by a constitutional instrument, make regulations for the efficient performance of the functions of the Judicial Service and the Judicial Council under this chapter. So you can see that I've removed the approval of the President. Why do we need the approval of the President to make such regulations, if indeed the judiciary is supposed to be independent of the executive or the presidency? So amend Article 159 to remove presidential approval for judicial rules, change may to shall, and this will ensure full procedural independence. And then what are the arguments for my changes? First, the judiciary is an independent branch of government and should have full control over its own administrative and procedural regulation. Second, requiring presidential approval undermines judicial autonomy and creates the risk of executive interference in the management of the courts. And third, removing executive oversight ensures that judicial rulemaking is insulated from political influence. Then, second, we need to ensure mandatory rulemaking for judicial efficiency. It has to be a mandate. You cannot just get up and issue directives. It's not done anywhere. Changing may to shall makes it mandatory duty for the Chief Justice to issue regulations ensuring that the judicial service operates efficiently and effectively. This guarantees that the judiciary always has a clear regulatory framework rather than being dependent on discretionary rulemaking. And I mean, it's implied, but maybe we need to highlight that any directives and so on that do not follow the rulemaking format or process stipulated will not be binding on anyone. I don't think it should be said, because it's clear that if there is a process for making rules, if you don't follow that process and you issue a rule by fiat, that rule by fiat shouldn't bind anyone. I had the same problem with the General Legal Council some time ago, when by fiat they said students should do interviews and do entrance exams. That went to court, and the court basically said, yeah, you cannot do these things by fiat. Nevertheless, I don't think the Attorney General has educated other bodies enough to allow them to appreciate that rulemaking is important, and you can't just make rules by fiat. Of course, this aligns with international best practices. Nothing interesting there. Summary: this amendment eliminates executive influence over judicial administration, will mandate necessary rulemaking, and uphold the judiciary's independence. It reinforces the separation of powers, enhances judicial efficiency, and strengthens Ghana's democratic institution. Now, the last item is about depoliticizing the removal process of the Chief Justice. Let me be very, very clear that I don't think any constitutional officer should be removed for political reasons. And I will never be a part of any process to remove a constitutional officer if it is tinged with politics. Having said that, I also think constitutional officers should be held accountable. So when they violate the Constitution, petitions must flow for their removal. Such petitions are not political documents. They are attempts to enforce the Constitution. That is a duty that all citizens have. So we must distinguish between political removal and petitions that are well grounded and that seeks to hold officers accountable. So here I say the appointment of a removal committee for the Chief Justice. This basically recites, this is my proposal. So where the petition is for the removal of the Chief Justice, the President shall, upon receipt of the petition, refer the matter to the Judicial Council, which shall determine whether a prima facie case has been established. Because, I mean, really, determining whether a prima facie case has been established is a very simple threshold process. But I've read decisions on prima facie that made me go, do these people even understand what prima facie is? I mean, they went into adjudication and they went into defending the person who was being removed, or who the petition was directed. And so I think politics entered into the prima facie determination phase. And that's why I'm proposing that prima facie determination maybe should be assigned to the Judicial Council. And then if the Judicial Council determines that a prima facie case exists, then maybe the President shall appoint the committee. So bring the Judicial Council to determine the prima facie case, and then let the President appoint the committee. Or even if we want, we can let the Judicial Council appoint the committee. Indifferent to that. So what are some of the justifications for the proposal? Under the current framework, the President plays a role in deciding whether a prima facie case exists, creating potential political interference in judicial independence. By transferring this responsibility to the Judicial Council, the decision becomes purely institutional and legal rather than political. Of course, I want the Council of State to be replaced by the Judicial Council. And I say here, since the Council of State is proposed for abolition, I propose that the Council of State be abolished. The Judicial Council is the most appropriate alternative because it's composed of senior judges, legal professionals, and justice sector representatives. This ensures that judicial peers, rather than political appointees, oversee disciplinary proceedings against the Chief Justice. And the third reason is that the Judicial Council is a professional body with expertise in legal ethics, judicial conduct, and due process, making it better suited than the executive to assess allegations against the Chief Justice. This prevents politically motivated removals while ensuring that legitimate complaints are fairly examined. And then it retains a balanced removal committee. The composition of the removal committee remains independent and diverse, ensuring fairness in proceedings. By allowing the Judicial Council to select the Supreme Court Justice who chairs the committee, this further eliminates executive control over the process. Summary, this amendment will eliminate political interference in the removal of the Chief Justice, ensuring an impartial and independent judicial process. By placing the prima facie determination with the Judicial Council instead of the President, the amendment strengthens judicial independence, protects against executive overreach, and reinforces the rule of law. So that's it. Let me make one or two concluding remarks. The key goals of my reforms are to prevent court parking and politicization, to improve transparency in judicial appointments, to promote efficient and professional court operations, to enhance legitimacy in constitutional jurisprudence, and to remove President from the process of making regulations and making judicial determinations. These targeted reforms offer a balanced path forward. They offer practical reforms grounded in Ghanaian realities, and they reflect global best practices. They strengthen rule of law and the public trust in the judiciary. Thank you, Mr. Chairman.
Thank you very much, Professor Asare, for a very well-structured, very straight to the point presentation with proposals for amendment. The practice on the committee is that once you have made your presentation, members of the committee who are interested in probing further will take turns to make some remarks or ask you questions, and then we'll open it to the floor, to the larger audience here at this meeting to also ask questions of the presentation you've made. So I have here in person 4 other committee members. Professor Kwame Kakari is here to my extreme right. He's off, even though he's left. He's to my extreme right. Godwin Jokoto, Dr. Godwin Jokoto next. Mrs. Charlotte Osei and Justice Sophia Adingra. The other members will join in the course of the day. So any one of you can take your turn, or if not, I will ask. Go ahead.
Thank you very much, Chairman, and thank you very much to Professor Asare. In fact, we've learned a lot from you this morning. I just have a couple of questions for you. I just want to pick your mind on whether Ghana needs a constitutional court, looking at the workload that the Supreme Court is burdened with. Would you say that we should set aside a court, which we will call the Constitutional Court, to deal specifically with the questions of interpretation and enforcement of the Constitution? Then I want to find out from you what will be your measure in determining what the Constitution refers to as high moral character and proven integrity as one of the requirements for appointment to high judicial office. And I also want to find out from you if you think Ghana needs a Deputy Chief Justice, and if so, why, and if not, why not? Now, a lot has been said about access to the Supreme Court, even in terms of motions. And some suggestions have been made that when it comes to the hearing of motions in the Supreme Court, it should be limited to maybe a sole judge and not the entire panel, unless the matters are of grave issues of public interest, which should require the entire Supreme Court to hear such matters. And I would like to pick your mind on this matter. Then you mentioned in your presentation that you are recommending that with the appointment to the High Court and the Court of Appeal, the judges should receive the approval of Parliament. And by that, do you mean they should be vetted? I think. And then finally, I want to find out from you if you think it's good practice for the senior-most judge of the Supreme Court to be appointed as the Chief Justice. I thank you, Mr. Chair.
Good. Prof, how are you? I want, in fact, I agree with your suggestion that on constitutional.
Sorry.
On constitutional matters, there should be 9 justices.
Professor, can you hear us from here?
Yes, I can hear you.
Okay, so it's Justice Adinira has the floor now.
9 justices to sit on constitutional matters. So if we have a whole Supreme Court of 11, that means almost all the members are being empaneled, which is very good, because I have always been of the opinion that all the members of the Supreme Court in existence should sit on a constitutional matter, leaving 2, so that they can be added when there's an application for review. So that also is in a good direction by enlarging the panel for constitutional matters from 7 to 9. And I also wanted to know your reason for leaving out the Judicial Staff Association from membership of the Judicial Council.
Good morning, Prof.
Professor, I think we are not done yet. Mrs. Osei will take her turn, and if you can actually, when you're answering, if we can, it's okay if we can see your handsome face.
Prof, good morning. Just one question, please.
Good morning.
If we cap the number of Supreme Court judges at 11, the number of cases that also come to the Supreme Court so that they are not overburdened and they can focus on the serious constitutional matters. Thank you.
Okay, Kweku, so I have the mode of appointment. So you would have the CJ and other justices of the Supreme Court appointed following prior approval by Parliament, 60%. Every time you require a supermajority, you have a risk that you may not attain that supermajority, right? So what if you go through there's a vacancy in the position of CJ, you've tried 1, 2, 3, 4 times, you can't still get 60%. What's the default rule here? I mean, or what's the fallback, not the default? What's the fallback in case you are unable repeatedly to get your 60% or supermajority? You also would have the Judicial Council present the nominee for appointment, be the one to, I don't know if you are originating the nomination from the Judicial Council or if you're originating it from the president and then the Judicial Council just takes a look at it. It's not clear, where the division of labor is between the Judicial Council and the president, if the president is involved at all. And you also didn't indicate any process by which the Judicial Council will come by the nominee. So we don't know, you leave it silent. Is it one of those things that they would decide, by some CI how to do it? You mentioned that it's for transparency, so I was expecting that you would maybe give us an idea whether or not you expect the Judicial Council to do an advertisement, to interview candidates, Kenyan style, or how are they to come by the nominee that is then proposed for approval and appointment. Then on the caps, Article 128, 138, 139, do you leave room for expansion, especially in the lower superior courts? So Court of Appeal, or especially the High Court. If we leave it unclear how you do it, is it by legislation? Do we have to amend the Constitution if these being entrenched provisions? If you cap it and you don't tell us how procedure, referendum, just to increase the number by 1 or 2. So would you have us do it by legislation? It could be by supermajority if we want to expand it. My own reading is that a residual clause of the Constitution actually covers this, where it's silent, but that is not necessarily the practice, probably also not the common understanding. So if you are capping it, what's your proposal in the event that we want to raise the number in some future time? Now, on this issue of the bench, the constitutional bench being 9, I think Dr. Jokoto also asked if you would be in favor of a constitutional court. And I think Charlotte has also just asked, Minister has also asked that, given the volume, right? One of the responses to this issue about the size, which I don't necessarily buy, is that, the caseload is, is just plenty, and therefore, and vast, that the court's jurisdiction is multiple, it's original, appellate, supervisory, review, all of that. What if we actually broke up the Supreme Court into 2, right, and said we will create a constitutional or original jurisdiction division of the court? On the same Supreme Court, we create 2 benches, 2 divisions. One for original jurisdiction cases, one for appellate cases. Now we can work out how that is done, whether or not we have overlapping judges or whatever, but the Chief Justice sits on both. But we've created 2 benches, and so that we can parcel out the jurisdiction, and it also reduces I see that part of your design here, even though you didn't specifically talk about empaneling, the effect of many of your decisions here is to basically either reduce considerably or take away the Chief Justice's power of empaneling. You didn't say that specifically, but the net effect of many of your proposals is to do that. I support that proposal. In fact, I think that we should find a way to, as much as possible, eliminate that power of the Chief Justice through constitutional design. But one way I would propose, given the number that we have now, so you want 11. Already it's about 19. I don't even know what it is now. Right? So it's way gone past that number. To bring it back to 11 would mean, you have to wait for attrition of some sort over time for the number to come to 11. If we kept the number at, say, 17 or thereabouts, we could break up the court into 2. You have an appellate division and you have a constitutional division, or a general division, or regional jurisdiction division, and then the judges on those 2 benches will have a reduced caseload, presumably because they would not be doing both. And then the CJA just sits on both. How does that look to you? Do you have a role for review jurisdiction in your proposal? You didn't say anything about it. If you're going to have 9 justices on the constitutional cases, the Ghanaian practice has been to enlarge the court by the addition of other members of the bench when it goes on review. I happen to think that is actually a wrong practice. It turns the review almost into another like an appeal. The idea of a review is like, you are telling the same judges that you think that they missed something, so they should take another look. It's not to bring in a third eye or another eye to look at the same case. But that is the Ghanaian practice. We add other justices to that. Are you in favor of the current practice remaining? I support your proposal to remove the Chief Justice from the other superior courts. I think it's old colonial legacy. That's how our court, from the Supreme Court Ordinance of 18 whatever, that's how these things evolved. Other countries have done away with it. Kenya most recently, the Chief Justice just sits on the Supreme Court, not on the Court of Appeal or High Court, and I favor that practice. The Judicial Service, the Judicial Council, you would reconstitute it. I don't think I have much of a, but you say it's advice, more or less an advisory council to the CJ, except that you have a role for it in the nomination to the bench. Would you maybe expand on its functions? Then the regulations, I agree, we encounter the same problem with the Public Service Commission, which has, in the Constitution, it says the Public Service Commission may, by constitutional instrument, in consultation with the President or with the approval of the President. So I think the change you want to make here would be consistent with the change that is proposed for how the Public Service Commission makes its rules, which should be by CI. And then the last question, I haven't heard much about, or anything said about the Judicial Secretary. There is mention of that office in the Constitution, and of course there is such an office in practice. I'm not exactly sure. So the CJ is the head of the judiciary, right, administratively. But we have a Judicial Secretary, who I also understand is part of the administration. Maybe the equivalent of the chief director or whatever, I don't know. What is the appropriate division of labor, you think, between the Chief Justice and the Judicial Secretary? The current practice, it looks like that even the Judicial Secretary is now a judge. And also it's like the Chief of Staff of the CJ. I don't quite understand what exactly the role is here, but I think many of the problems people might have with the office of CJ, it's not so much in his or her judicial role as a jurist. It's mostly in the administrative role. I think that is where all the power has gone to. The CJ has become very powerful by virtue of accumulating a great deal of administrative power, which power can be used in ways that might affect the decisional independence of his or her own colleagues or of judges in the Superior Court structure. So exactly what would you say about just this kind of power and how we might regulate it? Some of your design ideas, I think, go to that, but is there a more explicit way of saying this? For example, Article 296, the Chief Justice's powers are exercised almost as if Article 296 really does not apply to that office. France versus Attorney General, I think you were the lawyer in that case, were you, or not? I mean, this is this Electoral Commission case where Justice Dateba read 296C out of the Constitution and said that it would be nuclear meltdown. Now, if we use Article 296C, and I understand it to apply even though it says that if it's a judicial officer, but when the CJ is acting administratively, he or she is not acting in a judicial capacity. So that is not the problem. I think that each time you act in an administrative capacity, you are caught by Article 296C properly interpreted, right? So would you make a proposal more explicit that where the CJ has discretion, that it must be bound by 296, or whether it's A or B or C in that regard? Then you said, even though you acknowledge that the lower courts are important, we no longer call them inferior courts. Would you think about that too? Because, like I said in my opening remarks, that is where most Ghanaians face justice or suffer injustice in the judicial system. It's at the district courts and circuit courts. And the provisions there about the independence of their judges, they're almost not independent at all. They don't have the same kinds of protections. I think they basically, between the CJ and the president, they basically control that area. I would be glad if you could actually spend some time also to reflect on that segment of the court system. Thanks. It's a question for you.
Yes, Professor Sari, thank you very much. I have learned a lot. I have two questions. Your proposals seems to me to really promote very much the independence of the judiciary. And I think every democratically minded person in our country will be very unhappy with executive interference in the judiciary under any circumstance. And you've helped by proposing ways by which the executive is removed from the removal of the Chief Justice. However, I would like to find out from you, under what circumstance can the executive petition for the removal of the Chief Justice? Or is it that the executive must absolutely be barred from petitioning for the CJ's removal under any and every circumstance? My second question follows from our chairman's last point about the lower courts, but this is not about the lower courts. I don't recall that you made any comment on the regional tribunals, which are also to be found in the Constitution. What are your thoughts on that institution? Thank you.
All right. Let me drop this one last one for you quickly before you take your turn at your last proposal on the removal of the CJ. You said that it was to promote accountability, and I understand that. But your proposal turns the judiciary into an almost exclusively self-regulating institution, right? You keep politics out by keeping the president, by bypassing the president in the examination of the petition, which I think is a good idea. But you leave almost the entire process as basically very much within the judiciary, right? Or within the Judicial Council as you have recomposed it. How exactly does that promote accountability when you have a council of chaired by a Supreme Court justice, not the CJ, in your new proposal, and which includes other judges and mostly lawyers being the only ones who are involved in this process, right? I mean, wouldn't it turn into this insular, eventually become a mutual back scratching kind of institution if that is the only body that can actually have a say-so in the process for the removal of a chief justice or any other justice for that matter? Now, on accountability, being a serial plaintiff in the court yourself, what would be your reaction to a proposal about publication of judicial decisions? Because it's become very irregular. I don't practice in the courts, but I know lawyers who get ambushed in the courts sometimes because the other lawyer has a case they don't have. Somebody has a law on a matter, you didn't even know about it because it's not published. The idea that a law that is not published, because judicial decisions are law, and the reason we gazette legislation is to put it out, make public notice of it, so that you know that there is a law that has been passed by the judiciary, and that is has been passed by the parliament, and that is why we say ignorance of the law is no excuse, because we put you on notice that it's been published. It's in the Gazette. You should have known. But when judges don't publish their decisions, there's no law report. You can't find it on the website. It's nowhere, but it's somewhere, but it's not published. What is the status of that? What kind of accountability regime would you propose to make sure that we have judicial decisions published so that people become aware of the latest case law in the particular area? That you need to take down your... he's done that already, okay. Okay, Gweku.
All right.
Yeah.
Thank you so much, Mr. Chairman. Those were a lot of excellent questions. The good news is I didn't write them down, so I've forgotten what the questions were. But let me try and answer as many of them as I've written down, and then we could proceed with the conversation. I think one that you asked, and then I also think the first panelist, I believe Mr. Jokoto, was that right? The first person who asked the question, I couldn't remember the name. But yeah, okay. So the question was about having a constitutional court. And I don't believe it is a bad idea. There are about 80 countries in the world that have constitutional courts. So it won't be a problem if we decided to do the same. But we need to be clear on the type of problem that we are trying to solve, and then convince ourselves that creating this separate jurisdiction is the answer. Too many times, I think we try new ornaments and then we find out that they are not solving the problem. A good example is the ceremony surrounding the creation of the Office of Special Prosecutor. And we are almost back to where we used to be. Now, let's remember that most of the countries that have these constitutional courts are of the civil law genre. They come from the civil law. Our traditions are rooted very much in the common law, the Commonwealth legal tradition. And this promotes, or this has a more unified court structure with the Supreme Court at the apex handling all issues. So it's a unified court that promotes coherence and efficiency. The Supreme Court, maybe not now, but we've had Supreme Courts that have a strong track record that I think we should try to reclaim, not abandon. And I'm talking about the Supreme Court that decided, for instance, the December 31 case, or the Supreme Court that decided to for, and I could go on and mention a number of interesting cases, MPP versus IGP, and so on. So we've gone through a golden era of very interesting, rights expanding, governance enhancing decisions given by the Supreme Court. And we need to ask ourselves, well, why are we now not so happy with what is going on? When we address the question from that angle, it becomes a little clear that the problem is not so much this court has too many things that it's looking at, and therefore let's break it into different jurisdiction. It is deeper, and I think some of the issues that I raise, the appointment process, the empaneling of justices, and so on, address the unique Ghanaian problems that we have more than just creating a new structure which is divorced from our traditions. Furthermore, I think our current structure avoids fragmentation, and I'm afraid if we start going to that route, there's fragmentation, and that is going to lead to sometimes jurisprudential incoherence because the courts are saying different things, and maybe they start competing with one another that we are better, we are the better Supreme Court and you are not. So I think, and I'm not against the idea of a constitutional court, but I think our emphasis should be on institutional reform that focuses on strengthening, not splitting the jurisdiction of the court. The lessons from other countries that have also gone this way should also be a tale of caution, that the grass is not always greener on the other side. So my conclusion on that is that we don't necessarily need a new court. What we need is to preserve and strengthen the one that we already have. The Supreme Court is already empowered, it's historically tested, and is structurally integrated into our legal and democratic architecture. Creating the constitutional court, I'm afraid, risks duplication, fragmentation, and yes, maybe even confusion, while undermining, in my opinion, the institutional capital built over decades. This is a time where I believe we need stability, we need clarity, we need credibility in the rule of law, and I'm going to guess that our best move is not to experiment, but to deepen our commitment to the Supreme Court as the guardian of the Constitution, albeit a significantly reformed Supreme Court. So that will be my thoughts on the question that you posed, as well as was posed by my good friend, Mr. Jokoto. I think, Mr. Jokoto, your second question was on high moral character for appointment. And I think this is understood in the common law to refer to people who have been convicted of crimes of moral turpitude or dishonesty and so on. I think Article 94 2A or thereabout lists a series of criteria that can be used, whether you are a bankrupt, convicted, whether adverse findings have been made against you by a commission of inquiry, and so on. So I think even though the language says high moral character and integrity, and on its face, it appears to be too subjective, our laws have evolved to define boundaries, parameters around that. So I'm okay with that. It's not just in the appointment of judges, it's even in the call of lawyers to the bar. You have to have high moral character and integrity and so on. And we all know what it means. It's not as threatening as it appears to be on paper. Your third question, I believe, was, should a deputy chief justice be appointed in the same way that we appoint a chief justice, for instance? And my answer to that will be no. I believe the current practice of the most senior person acting as a deputy whenever the chief justice is not able to perform his or her functions is adequate. And your fourth question, I think, if I have not missed anything, is about whether motions should be heard by single justices of the Supreme Court. I agree, and I think that is also the current practice. Furthermore, I think our courts are too tolerant of, they spend too much time hearing from people, getting people to come to court and then adjourning and so on, when the issues that are put before them, whether constitutional questions or appellate questions, are strictly speaking questions of law that can be resolved without the appearance of the parties in court. So I think they should develop this tradition of sitting on cases and issuing opinions without necessarily having the parties come there to basically tell them what is already in their briefs. And I believe that will save them a lot of time. Many times we are talking about caseload, and the court has too much caseload. I think a couple of people raised that. Perhaps my good sister, Madam Charlotte say, and I think Mr. Chairman also raised that caseload. Ghana's Supreme Court does not have a big caseload when you compare it to the caseload of the Supreme Court of Kenya. That has only 7 justices. The caseload there is way in excess of ours. And if you compare it to even advanced jurisdiction, then it is worse. The problem is how we manage that caseload. And so that's where the emphasis should be. All these issues of the parties getting together, agree on issues and so on. I mean, why can't the plaintiff write his brief and put his issues in there? The defendant put his issues in there, and the Supreme Court, they meet and they can decide which issues are important they are going to address, and then they address those issues and give us an answer. Why should the parties go and meet and then you are looking for the defendant or the attorney general so that you can agree on issues, and then you come and it's all a waste of time. It doesn't enhance the decision-making process. So I agree with you that many motions can be heard by one person, and more than motions being heard by one person, many of the cases can be decided without the parties having trooped to the court to tell the judges what already exists in their briefs. And then I think you asked whether approval, when I proposed that judges of the High Court and the Court of Appeal be approved, do I mean vetting? Do I mean vetting? In a sense, yes, but remember that we have a case, J.H. Mensah, which tells us that when you say Parliament should approve a nominee, then Parliament itself should be allowed to evolve its methodology for that approval process. And the current methodology is vetting, which when you listen, it's not very interesting or informative. But I think when we ask them to approve, then we should leave it to them to evolve their own methods. I would be against a rule which tells them to approve, do X, Y, and Z. I think that would be harmful. Yes, I definitely will, not just for the nominations to the court, but even when it comes to sector ministers. I mean, we have sector oversight committees. So why don't we allow the sector oversight committees to vet the nominees that they are going to exercise oversight on? So I totally agree that it is bad practice for us to have an omnibus appointment committee. It doesn't serve anyone well. If you listen to the vetting that went on recently, the people who were asking the insightful questions were members of parliament from the relevant committees who were just invited there to participate, but they knew the issues. And so they were able to ask more probing questions. I totally agree. And I've had the opportunity to suggest that to the speaker, Speaker Bagman, and I believe the current standing orders are moving in that direction. But the problem that they had this time around was the committees were not constituted at the time the vetting was being made. So in the future, we need to devise some strategy of getting this committee in place as soon as possible, and in any event, before any vetting takes place. But to your question, I definitely agree that the Legal and Constitutional Affairs Committee should be the ones that vet the nominees to the Supreme Court. Now, I think your other question was, do I believe the senior most person on the Supreme Court should be appointed as the Chief Justice when there's a vacancy? I don't think so. I don't agree. I think the Judicial Council should, and I think I also want to address the question that Chairman raised, that when we say the Judicial Council, what processes should the Judicial Council use? And I didn't have the benefit of talking about all my recommendations, but if I may refer the committee to my recommendations on the Electoral Commission, I talked about reforming the appointment of Electoral Commission members and other constitutional bodies. So the proposal there was to establish a transparent and merit-based appointment process by amending Article 42.3.2 and other articles to introduce a structured selection process for appointing, I'm talking about the EC, for appointing the EC chairperson and members, as well as leadership of other independent constitutional bodies. We may include judges in this position, or Supreme Court judges at least. The proposed process would include public advertisement of vacancies, the formation of a selection panel, a public interview process, nomination of candidates, and then presidential nomination, the rate of appointment or rate of nomination, and then parliamentary approval. So, Mr. Chairman, I would say that my recommendations in the proposal that I sent to you under the Electoral Commission should be adopted when it comes to that. Now, Justice Adina, good evening. Is it afternoon? Good afternoon. It's good to see you. You're looking great. It's still morning. Okay. Good morning, Justice Adina. So I think you asked whether the deputy CJ should be the most senior judge, and I agree that that should be the case, especially since the deputy will be performing that role for a very short period of time. And I'm happy that you agree with the panel enlargement, because you've lived on the Supreme Court. And so this is something that you can talk to based on experience. I noticed that Justice Atuguba, for instance, said it publicly that at one time he had a fallout with the Chief Justice, and for 6 months he was not put on the panel. And that's not something that should happen. The paneling process, I don't even think the Chief Justice should be involved. The paneling process will be done by the court registry using software. These days, there are all kinds of software that assign cases to judges. And so it's just a question of investing in the technology so that these assignments are done at the registry level, not at the Chief Justice level. I believe it's a mistake for that to be done, for the Chief Justice to be empaneling judges. And there's nothing in the Constitution that really says Chief Justice has any power to empanel justices. It's just some NLCD 64 and Akufo-Addo versus Kwesi Aiden. I think it's a 68 case. And we are still relying on that, even though we've had 2 or 3 more constitutions after that, and all the constitutions have not indicated an acceptance of NLCD 64 and then the Kwesi Aiden Akufo-Addo case. So I think empaneling is a big mistake. And then my sister, Miss Charlotte said, it's good. Oh, okay, here. So I believe I've answered your question about whether when we limit the number of justices, whether the justices will, I don't believe that is so, because everywhere, it's the fact that our courts have appellate jurisdiction for hearing constitutional case and so on. This is not unique to the Ghanaian Supreme Court. This is traditional of all courts. They wrote a report and I read it. The average case per year was about 600. That pales into comparison when you benchmark that against Kenya or some states in the US, because I live in the US, California Supreme Court, 7 justices, they hear about 5,000 cases or they address 5,000 cases. But they are doing that because they are not going into this process of getting people. You send them your briefs, they read the briefs, and then you get a response. And that's the way we need to go. And then let's see. Oh, I think Chairman asked a question about if we say justices should be approved by a supermajority, it may lead to gridlock. And then if it does, what is our fallback position? In fact, the whole idea of requiring supermajority is to avoid gridlock, because what it forces the person doing the nomination to do is to put forward a candidate who is acceptable to all sides, or at least who is not heavily political in the sense of party in the minority. He should be someone who both sides will agree this is good. And I think we can find judges like that in the country. I think we can find people to go and work on the electoral commission like that in the country, and so on. There are many people in the country who people can identify. Oh, this guy is an NPP guy. I have no problem if he sits on the Supreme Court or if he acts as the chairman of the electoral commission, because he's an independent NPP person, or for that, he's an independent NDC person. We need more of such people who think like statesmen and less of the partisans that are populating our independent constitutional bodies. Many of the problems that the independent constitutional bodies are having, it's not because of a structural flaw as such. It's because we are putting too many partisans on there. And the way around resolving that problem, I think, will be to elevate the threshold for appointment to a super majority. Let's see. Oh, and then I think you asked a question about where the nominations should originate from. And maybe the language is unclear, and I think the committee should use clearer language. When I say the president acts on the advice of the Judicial Council, then I'm suggesting that the nomination originates from the Judicial Council and the president simply performs a ministerial role of issuing a writ of nomination. And our constitutional law has evolved. That's why I said we come from the Commonwealth tradition, where, for instance, if you look at the 1957 Constitution, it talks about the president, not the president, the prime minister. At that time, he was the prime minister. The prime minister appoints, they used to call them parliamentary secretaries, acting, I mean, not the prime minister, the governor. The governor appoints the parliamentary secretaries acting on the advice of the prime minister. The governor was Aden Clark, representing the queen or the king. The prime minister was Kwame Nkrumah. And if you read the constitution literally, it's almost like the governor is the one doing the appointment. But no, but that's just the way that we write our Commonwealth laws. When the law says you act on the advice of somebody, you are simply performing a ministerial role. Yes,
Meaning of the constitutional law, our constitutional law, based on that case, says advice means advice, right? So you are saying that we should overrule that case essentially.
And I think, yes, absolutely. And even in that case, you see that when it comes to there are two components of that case. One was a GBA case, and then the other was I've forgotten the party to that, but when it came to the GBA case that dealt with the judiciary, Justice Atuguma was actually clear that when we talk about advice, it is binding unless you discover some other violation of the Constitution. For instance, if the president finds that the judge lacks moral integrity or something like that, then he will not be bound by it. But other than such discoveries, Atugba makes it clear that it's binding. Nevertheless, I totally agree with you that the current law, it appears to be that advice means advice. So I would urge the committee to rewrite that in a way that does not invite confusion. So maybe the Judicial Council nominates or something like that. And I'm sure you can do a very good job of writing it. And then I've already referred you to the EC appointment process. So that's the same process that could be used here. And then you also add, where there are caps, should there be room for expansion? Probably not, because caps are caps. And I'm not sure why we want room to change that. But I noticed that the provision on caps are not entrenched. So if at any time there is a strong demand based on some objective realities to amend it, then it can be amended to expand the number. But I think that the Constitution itself should be firm that a cap is a cap and not leave any wiggle room for it to be manipulated by people seeking to pack the court. Already, I believe, address the caseload, and I think Chairman asked a question about what is my opinion and the review, the Supreme Court's review jurisdiction. Frankly, I don't like it. I believe there is only one case, to my knowledge, where the original panel's decision was reversed. Other than that, almost all cases, the original panel case is affirmed. And the case where the original panel case was reversed, if you remember, it created a lot of confusion in the country because it was believed that Kufuor had packed the court to reverse the original panel's decision versus Attenborough. The history of this review panel has been one of very little success, and so I believe that yes, we can get rid of that, but if there's a reason to maintain it, and I'm not going to lose too much sleep over that. But I agree with you, Mr. Chairman, that this historically has not been very, very good. And then I think a question was also asked about if the Judicial Council plays an advisory role, why are we involving it in nominations? I mean, they play an advisory role plus other functions assigned by the Constitution and other laws. So if the Constitution assigns them a function, then yes, they can play that role. The question about the Judicial Secretary is one that is interesting because honestly, I've not given it a lot of thought, and I might need to think about it some more before I can speak cogently about it. But I note that the current Judicial Secretary is also a member of the Court of Appeal. I don't know why we would allow that, because I see the Judicial Secretary's role the same way the chairman sees it. is more or less a chief of staff for the Chief Justice, because the Chief Justice is very busy with judicial functions. He needs a full-time person handling the administrative responsibilities. So I would suggest that the Judicial Secretary be a non-judge, a manager, somebody who manages the judiciary. They could go to the School of Administration and hire a manager rather than use the existing judges. And there are a lot of complaints about the current arrangement. So I'm going to leave it at that. I also think, or if I recall, that one of the questions that was asked was whether the removal process will bypass every other institution and leave it solely for the judiciary. I think if we look at the role that I'm assigning to the Judicial Council, it's a very simple rule. Determine whether there's a prima facie case. Determine whether there's a prima facie case. Unless a petitioner has fallen asleep, invariably, the petition will meet that test, because prima facie, it's a legal phrase, which means looking at the four walls of the petition, have credible questions been raised that warrants the setting up of a committee to go into it. And if you look at Article 146(7), it says only the committee shall inquire into the petition. But what we've had is a president who takes a petition and actually inquires into the petition and says, no, the Chief Justice is right, you are wrong, and so on. Well, how can somebody who is determining a prima facie case go into adjudication? That is the job of the committee. And then when you look at the committee, you see that 60% of its members are supposed to be non-lawyers, non-judges. They can't come from parliament. So it says appoint 2 people from the Supreme Court and then 3 people who are neither lawyers nor MPs nor and so on. So that is where I think the public participation comes in. So I'm not too concerned that the Judicial Council is determining prima facie, because I really think the prima facie is a very, very, very low threshold to scale. And unfortunately, it has been politicized, because I myself was involved in, to be honest with you, I myself was involved in a petition. And when I read the president's response about prima facie case, I said, this is politics, because this has nothing to do with determination of a prima facie case. So I'm not too concerned about bypassing or creating an insular process that involves only members of the judiciary. All they have to do is to determine whether there's a prima facie case. And by the way, I think in determining that, if you disagree with them, you can actually have it judicially reviewed. If you resubmit it and they continue to do politics, then you seek judicial review of that, because the task is very clear: determine a prima facie case, and that's all you have to do. You mentioned lower courts, Mr. Chairman, and I agree that unfortunately I haven't spent too much time in my proposal, but I agree with you that we need to think about the appointment process. If I recall correctly, the appointments to the judicial, to the lower courts, or what used to be the inferior courts, are done by the Chief Justice, and there's no oversight whatsoever. So that can be reformed as well, to make it something that the Judicial Council does. I don't think there should be a prior approval by Parliament. because of the nature of their jurisdiction. These are, their jurisdiction tends to be very limited. And what we need to do, what the lower courts need, is infrastructure, is technology, and so on. I don't think they have issues that pertain to constitutional reform other than the appointment process. But I believe they handle, you look at the Supreme Court caseload is about 600. The lower court's caseload is over 20,000. And a judge on average is doing over 1,000 cases per year. So we really need to look into that. We need more lower court judges. But they need technology. They need research assistance and that kind of thing. So that's where I will leave that. And then, good brother, Professor Karikari, who for some reason is sitting on the right of Mr. Chairman, notwithstanding his left inclinations. He asked whether the executive be barred from the petition process. And if I understand the question correctly, you were asking whether the president should be barred from submitting a petition, not whether the president should be involved in the petitioning process. Those are two different questions. If it is the latter, then I agree with you that the president cannot submit a petition for the removal of a Chief Justice, because the Article 146 is a citizenship instrument, not executive instrument or a legislative instrument. It's an instrument that the Constitution reserved for the people. And there's an interesting case from Kenya, a BDI case, where the petitioning in Kenya, if you garner about 500,000 signatures or 1 million, depending on what you are trying to amend, then the Constitution amendment process kicks in. And there was this case where they gathered 1 million signatures, and the Supreme Court said, no, all that process comes to naught. Why? Because the president initiated that process. And what the petitioning process is all about is citizenship involvement, not presidential, not parliamentary involvement, and so on. So I believe only citizens can submit petitions. But when they submit the petition, there's nothing wrong with submitting the petition to the president. I don't like it when a president has to determine prima facie case. Judges are better equipped to do that. That's why I suggested the Judicial Council. And then, Mr. Chairman, you asked about publication culture, that this should be immediately on constitutional matters. They go out of their way to issue a one-pager clarifying what it is that they've decided so that the people themselves can know what it is. It's also time for us to build a credible database that incorporates all our laws, that is easily searchable, so that we can enhance lawmaking, we can enhance judicial decision-making. The current approach where people are hiding cases from one another, that does not advance the law. That, I don't even know what that is, because why would you hide a case? But I know that happens. And the reason it happens is because the cases are not widely accessible to people. We should make the cases widely accessible to people. And also, we should even open the jurisdiction of the Supreme Court to even lay people, so that if a lay person feels that his constitutional right has been infringed, he should be able to write a letter to the court and say, Judge, this and that happened to me. and the court should read it, and if they find an issue in the case, they should take it on, notwithstanding that the particular letter did not meet all the rules that are designated by the rules of civil procedure. In that context, I'll refer the court, and in this case, the committee, to India, where they allow this type of jurisdiction, and the whole country has been better because of that. And then I think one of the issues that I have not mentioned, because that issue was in chapter 1 of my comments. In my proposal to the committee, I do it by chapter, and so when I was invited to talk about the judiciary, I didn't mention this case. But I've proposed that anytime somebody files an Article 2 case triggering the original jurisdiction of the Supreme Court to resolve a constitutional problem, that should immediately be advertised, and anyone who feels he can contribute should be allowed as an amicus. Because after all, this case that the person sent to court is not personal to him. He's asking a question that interests all of us. So why should we allow that one person to be the only person who presents his views when other people may have different perspectives from different disciplines? Maybe there are sociological issues that the person is not considering. Maybe there are economic issues and so on. The courts should open its doors to amicus briefs. Currently, they actually close the doors to amicus briefs. And I can't understand why any court would say, I don't want to listen to people. I mean, the court should want to listen to people when it involves constitutional cases, because it's about those people. So that is what I would say. And then let's see. I think I may have forgotten some of the cases, questions, but that's as much as I remember, Mr. Chairman. Oh, yes. And that who is it that is reminding me? Who just reminded me? Mr. Prof. The reason I didn't answer that question is because I didn't want to answer it. I don't. Let me confess. I think we should remove the regional tribunals from our constitution. So, Prof, sorry about omitting your question. Regional tribunals. I don't understand why we need another layer to address our judicial issues. The High Court, the regional should be merged with the High Court, and then we just have a High Court, a court, and a Supreme Court.
In the very early hours of your morning in Florida, we had to accommodate you for this length of time and skip more or less our schedule for lunch, for tea break, because of the sacrifice that you also made on your other side, on the other side of the Atlantic. So we're very grateful. We have a number of people here, I'm sure, would like to follow up. But if you could actually, I mean, unless you have to go, we will take a short coffee break. And when we come, you can join us. You can join the conversation. There are other people who want to make some presentations or remarks. And if you stay around, you can be part of the conversation unless you have to go.
Yeah, unfortunately, I have to teach a class at 9 o'clock. That's in 40 minutes.
Okay,
so
good.
Mr. Chairman,
then you have to hurry. You have to hurry so that you can make it to class. before Trump gets you.
Thank you so much, Mr. Chairman, for
Thank you,
inviting me. I appreciate it.
and very enlightening. Thanks a lot for the time. So we'll take a break, and let's make it, because we overshot our time by more than 1 hour, maybe we just make a 10-minute short coffee break and come back.
the judicial process. And so I will decisions. There will be no room for, I think it's an issue that is topical now. And my proposal here is that the Constitution should be clear on the issue of prima facie case, which in the Ajechum case has been determined by the Supreme Court that the Chief Justice is also entitled to a prima facie case. So I think that should be clear in the Constitution in Article 1466 so that to not raise any future issues that may have to go to the court for interpretation. And as you know, the Supreme Court decisions can also be changed by, it can make changes to its own decision. So we don't know whether tomorrow that position may change. So if it is clearly specified in the Constitution, it will be helpful. So in that case, the President shall refer the petition to the Judicial Council. I propose that it should go to the Judicial Council, not the Council of State, which shall determine whether a prima facie case is established against the Chief Justice. And so it is the Judicial Council that should make that prima facie decision. Where the Judicial Council, and then we go to 1464, where the Judicial Council decides that there's a prima facie case, then it shall go to the committee. So that is what I propose, that we bring in the Judicial Council to determine the prima facie case so that it will avoid the conundrum or the controversy that we faced with this particular situation of the Chief Justice. And then it's also not clear in the Constitution about the right of appeal of a justice who has been, there's been a committee has determined that the justice cannot continue in office, or the Chief Justice cannot continue in office. I think there should be a clear provision that that person should have the right of appeal, most likely to the Supreme Court. And there may be a particular number of days that the person should have exercised that right. We also notice in the Constitution that there is no, if you are appointed a Chief Justice, you hold office for life, more or less. And usually we don't seem to have had issues with this because the Chief Justice would be probably in his or her 60s, also getting to a few years away from retirement. But I think there should be a clear provision that if maybe we happen to appoint a younger Chief Justice, the person would not hold power for a very long period of time. But so there should be a maximum number of years for the appointment of Chief Justice, probably 10 years, but this is just what I'm proposing. But there should be a discussion on that to determine the number of years that the Chief Justice can hold office. And in case we have such a provision, and the Chief Justice should retire before his or her time, that is after being in office for the duration that is constitutionally mandated, the Chief Justice should be allowed to continue to sit as a judge of the Supreme Court. This is similar to, probably we can use the example of the IGP who was just removed from office. That the question has been whether he can remain in office, continue to work with the Ghana Police Service since he is no more the IGP, whether he can occupy a lower position. But I think with the Chief Justice being already a part of the Supreme Court, that should not be a problem. Then another point which I want to raise, which is about petitions against judges which I think should be made easier or more flexible for ordinary persons to be able to bring petitions against any judge, right from the magistrates to the Supreme Court level, so that it will enable people to have a say in influencing the judicial process. That if maybe they can issue a petition for a required number of petitioners' signatures, then that should trigger a case where the Chief Justice can look into such complaints and find a way to make sure that a committee of a sort is set up to deal with the complaints that have been raised by the citizenry. I think that will bring me to the end of my comments on the judiciary. But I understand I have the freedom to talk about other issues in the Constitution that I may want to. I don't know if that can come later or.
I think we will. If you have a written submission, because we want to devote today to the judiciary and we don't have a whole lot of time, I think we will take your other submissions as submitted and then just stick to the ones on the judiciary so we can have more time to engage those ones. So I hope that it's a written submission, in which case we have it.
Not written yet.
If it includes rights, we have that coming up next week. If it includes anti-corruption, we have that coming next week. So there are a number of various thematic clusters that we haven't yet exhausted. So, but as long as it's written, we will give it consideration. But let's spend today on the judiciary.
Very well, thank you.
So thank you for your additional insights. We will take a round of questions from members who have questions, and then we will open it to the audience here for their reaction. And I hope we can do all of this before lunch break, somewhere around 2:30.
Thank you, Chairman. Okay, so I have a few questions on the judiciary, and I'm concerned more about the justice delivery by the lower court or at the lower court. Now, this issue is not talked about as much because the issues concern a constituency that probably do not have a voice. They are not matters, the superior matters that go to the Supreme Court that are usually political in nature, and therefore they're publicized, and the key actors in our society get involved in those cases. But the real issues concerning the delivery of justice at the lower courts. And as this question that I'm going to throw, I also want it to be addressed, not just by you, but my senior, Professor Tupare, if you have opportunity to also address it. Now, most of the decisions that are taken at the lower courts, and this is from my personal experiences, defy common rules of law, basic principles of law, established rules of law, until they are appealed against and they travel to either the Court of Appeal or High Court or the Supreme Court. Some of them get to the Supreme Court. It's only then that real justice is usually attained. Now, this happens because this is a constituency. If someone commences a matter at the district court or the district magistrate, he may not have the means to retain a lawyer to embark on an appeal process. And so as the lower court decides its fate, whether in distribution of matrimonial property, whether it's about land rights, whether it's about some other entitlements or rights that affect Article 5 of our Constitution, that person, if he doesn't have the means and the wherewithal to proceed to appeal, he's condemned to the decision by that lower court. And some of those decisions are really atrocious. Because we don't have time, I cannot recount them. But we know, as lawyers, that one of those decisions, the court decided that a widow was not entitled to the properties of her deceased husband, despite the fact that she was contributing to the cultivation and to the maintenance of a certain cocoa farm. Until it was appealed, and then finally she got some justice. No, she didn't even get justice. It was the case until there was some legislative intervention by PNDC Law 111 and everything. So my question is, what would you propose so that the quality of justice delivery at the lower court is policed? Can we do this by the elevation process? Because as a lower court judge, you are promoted to the hierarchy of the courts. How do we examine the quality of the judgment, for instance, so that will inform, this is just a proposal I'm making, that will inform whether or not you get elevated to the higher courts, from district court to the high court to the court of appeal, for that matter. Or, I know that just, and so is there a proposal or is there some insight as to how we can make that public so that we can enhance quality of justice delivery at the lower court? That's the first thing. The second point is on the exercise of Article 2.1 rights by citizens, and then how we evoke the supervisory or interpretive jurisdiction of the Supreme Court. And I'm aware that in every constitutional interpretative issue that comes before the Supreme Court, before they deliver their judgment, they will usually embark on, explore the question whether their jurisdiction has properly been evoked for them to go into the merits of the matter itself. But would you propose that in order that Article 1 and Article 130 provisions of our Constitution is not abused by citizens or perpetual litigants who, for some political expediency or for some other ends other than the acquisition of rights or true justice, 1, 2, 3, they run to the Supreme Court, they evoke the Supreme Court jurisdiction, and this is a court we know is already inundated with a lot of matters. I'm looking for insights or some proposals that can sieve what goes before the Supreme Court, for instance. What will qualify as a constitutional matter that will need their attention for us to deploy the resources of the Supreme Court to go into that case so that we can avoid, at first instance, frivolous matters that are addressed as constitutional cases when indeed they are not. Thank you.
Thank you very much, Mr. Chairman, and thank you, Prof, for your insights. Just 2 questions for you. I just want to take your reaction to a proposal which says that vacancies in the Court of Appeal should be advertised and the applicants should be vetted in public. What would be your take on this matter? And what do you think the role of the Ghana Bar Association or any grouping of lawyers should be in the appointment of lawyers to high judicial office? I thank you.
Hello. Okay. So my first question in reaction to your remarks, the removal provision, Article 146, you propose in the case of the Chief Justice, or I guess probably other justices too, that the petition go to the Judicial Council for the prima facie determination. What about having a committee of the Judicial Council that excludes the other justices on the Judicial Council? Right, because if it were to go to the Judicial Council as currently, you are not proposing a change in the composition of the council, right? It's a pretty large council. It is populated by people who have a judicial role and are connected to, and it's chaired by the Chief Justice. In Professor Sari's formulation, he would change the composition considerably, make it largely professional, judges, lawyers, legal academics, and that kind. So even if it was in that other formulation, in the revised form, I think when we're dealing with removal proceedings against a sitting justice, it probably is not, we should probably allow other persons other than colleagues of the judge or subordinates of the judge to be the ones making that prima facie determination. It's not a huge, it's not like a trial, but what would you say of that alternative formulation where it goes to the Judicial Council, but it is handled by a subcommittee or a committee of the council where we've excluded all the other judges? Then this right of appeal idea, I mean, that would judicialize the whole process, right? I mean, the whole idea of the impeachment proceeding is that it's a special proceeding. It's not a trial. It's not a judicial proceeding. But the moment you introduce a right of appeal, then you've converted it into basically a judicial process, right? And I don't know how exactly that would look like, that would play out. I'm a bit agnostic on that one. It sounds interesting. Sounds like you want to respect the due process rights of whoever it is that is facing this process, but the appeal idea changes the whole, it changes everything about the removal process, right? It turns it immediately into a judicial process. The maximum term provision, actually, that's it's what the Kenyans do. So Article 147(2), the Chief Justice shall hold office for a maximum of 10 years or until retiring under Clause 1, whichever is earlier. Clause 1 says you retire at 70, right? So, but then you say that if you were to, your 10 years were to hit before you really got to retirement, then you would stay on, right? Well, the Kenyans allow that, but then they say that if the Chief Justice's term of office expires before the Chief Justice retires under Clause 1, the Chief Justice may continue in office as a judge of the Supreme Court. I think that's probably, maybe, I like that modification of your proposal. Instead of just saying that they must stay on, if you make it elective and allow them to decide if they want to stay on, because it's not, I'll be Chief Justice before, I don't want to become an ordinary justice, So I think that may be something that will be a little bit of a small amendment to your proposal. Then the current, I don't know, you didn't say anything about appointment of High Court or Court of Appeal judges, right? That is currently almost like a black box, right? We know what happens with the Supreme Court justices. At least there is nomination. Well, there's some part of it is a black box, but what we see is that the president appoints, there is some process. We know very little in terms of transparency about the appointment of the other Superior Court judges. And because of I believe that the Attorney General has considerable influence or power in the making of those appointments at that level. And when you consider the role of the Attorney General as the chief prosecutor, more or less, as our prosecutor and all of those things, I think having the Attorney General participate non-transparently in that appointment process is a bit, somewhat that troubles me. I mean, and would you want to reflect on how we should appoint those layers of, because for the most part, not everybody will get to the Supreme Court, right? A lot of cases from High Court don't go all the way to the Supreme Court. We have this fixation with the Supreme Court, but in fact, for most people, you know, even if you went to the Superior Court structure, a lot of cases will end at the High Court level, really. After trial, that's it. You probably don't have the resources to prosecute it all the way to the Supreme Court. So, but we seem not to worry too much about how those judges are appointed. We just care about the Supreme Court. And I think we should put some, we should shed some light on how that appointment process goes. And on the lower court, I find my colleagues, I mean, I think it's something that we should really look at seriously. And maybe some innovation there might work. Is it possible that even though they are subject to the supervisory jurisdiction of the Superior Court, is it possible to distribute the work among the Superior Court judges so that they have like some managerial or whatever oversight of a certain cluster of district or circuit courts, right? And somebody must be looking at something they are doing, even if it's not come to your attention through the normal process of review, right? Because at that level, many people too don't have the resources to actually trigger a review so that your supervisory jurisdiction or whatever appellate jurisdiction is triggered. So it's a peculiar kind of structure, and I think that calls for some innovation. Is there a way we could actually do it such that maybe not to the Supreme Court, they are probably overburdened, but I don't know if the High Court or someplace where, you know, a certain number of cases in this district, this is the judge that can look over it small. I don't know how they do it, but I think just leaving it for them to trigger the regular supervisory jurisdiction, appellate kinds of, you know, will cause us to lose a lot of those cases in terms of oversight. We've done some work at CDD on justice at that level, and in fact, one of the cases was so egregious we had to report it to the Chief Justice at some point for action. I think the judge was eventually disciplined or removed. But we had done some work at the justice at the lower court level, and it's just really egregious, just completely terrible. You know, and a lot of, it does matter because that is where a lot of people form their perception of the judiciary, because that is really their only encounter with the court system. So when a lot of people say judges are corrupt, it's actually, that is where they are forming their opinion. And, you know, maybe a Superior Court judge may not like, may react, you know, with a bit of hostility to that accusation, but for the person who is the victim of injustice at that level, that is their experience, you know. So to the extent that that's where most cases go, I think we should spend some time thinking about the quality of justice delivery at that level and maybe find some innovation. It may not fall within the nice supervisory jurisdiction things that we are talking about, but something that works for that person at that level, I think is important.
Well, we have supervisory High Court judges. In every region, we have a supervisory High Court judge. He is in charge of the circuit courts and the magistrates' courts. And I know as a fact that it's even in the, that for criminal cases, all the judgments or sentences come to the High Court judge, so to review. So even if there's no appeal, and you realize that perhaps the sentence is too much, he has the authority to vary it without an appeal.
So how does it?
No, after the delivery, they will bring the returns of the cases determined all the district courts under your supervision, and then you have to look through. It's a tedious job, and say, okay, this case is assault, and the sentence is 5 years, but it's too much. Looking at the record, and then
How do we monitor that this is being done?
it's being done because I did some before when I was in Koforidua as a supervising High Court judge, and then for Accra, it is a Court of Appeal judge who supervises some of the courts. But sometimes the Chief Justice sometimes takes it upon the Chief Justice decides to supervise the regions, Greater Accra region, but now it's too much. So for a couple of years back, it's the Second Court judge who supervises the lower courts. So as for the criminal jurisdiction of the lower courts, the supervising High Court judge strictly have to look at everything. And even there's a provision where every 2 weeks, you must send returns of people on remand. So I remember that triggered the Justice for All in the prisons. And we were trying to decongest the prisons. And I worked with the CDD to draw up a program some years back. And then so they started the project where the court will go. And even I suggested that the Ghana Bar Association too should take upon itself that you know that they are remanded your litigant for more than 2 weeks as the law demands. Then you bring a report to the supervising High Court judge who has to look at it and they review it. The Criminal Procedure Code has got a lot of redundant provisions there. So actually, if the supervising High Court judge is very active and doing the work, you can review sentencing. But then perhaps you should also extend it to civil cases too as well. So that, let's say now in the regions, you have more than one High Court. Those days, let's say all the High Court in the Eastern region were in Koforidua, but now you have some in Oda, and Nkokwa and the rest, so that perhaps those cases could be sent to the judge sitting there, because one judge cannot manage all these district courts. So
if you have a mechanism like that, why is the justice at that level so bad? I mean, really, I mean, if there's something about the system, it probably is not working, right? Because the kinds of things you see there, you know, the kinds of things we picked up in our work, whether it's in Ada or Asante Achim or wherever we were, I mean, it cannot pass the basic test of justice, right? But that is what we found. And if you have these supervisory judges who can, on their own, without waiting for any suit or appeal to come before them, if they have to be reviewing it, then somehow that system must have broken down somewhere, because it's not.
I beg to differ. It hasn't broken down, except that the public doesn't know that it happens. So when you have reviewed as for the criminal, when you have reviewed it, then it is sent to the prisons. The registers know how to draft, and the sentences will be reduced, or some to go off. So that one to also, so that it is the supervising judges themselves who must be doing the work.
And it's to reduce sentences only?
Yes, to reduce sentences. You vary it, so most of the time, you don't increase, you rather reduce. That's the review. You don't increase, you reduce. And then, so if it is extended to civil cases, except that I feel to be too much for that to be added to the work.
Yeah, I think there's, I mean, the criminal cases, your liberty is at stake, right? So I think there's probably a good reason to limit it to those cases.
And then about appointments to the
lower
bench.
court.
In fact, The bar is actively, I don't know whether now we're not actively involved, because at least those days, it is by recommendation.
From the bar.
To the superior courts, it's by recommendation. And for the lower courts, it is advertised. And then you apply. And there is a committee that sits and does the sift through the applications. And then as the exams are set and the interviews are done, exams are set, and the results, it comes to the Judicial Council. And the Judicial Council will look at it and then make the appointment. I've been at the Judicial Council too, I know it happens. And we have committees within the Judicial Council, so that if the matter concerns the lower court, the circuit court rep there will be chairman of whatever committee. And then if it's the higher circuit court upwards, then the higher court judge will head whatever committee, whether selection or disciplinary committee. Then if the superior court, then is the Supreme Court judge who is there, who also comes, because higher court judges sit on panels there. So when you look at it, I asked the question, but he didn't get it. Why he has left out the Judicial Service Staff Association? The council is for the whole judiciary, including the administrative section. So they should be on the council.
No, but it's not for welfare. It's not a welfare council, is it?
No, but still they bring their concerns and they tell us what is happening at the court.
It's for welfare too.
There are problems. There are problems in the registry.
But the decisions affect the private sector too, but they are not there. I mean, if you say that, then the decisions affect everybody. Right?
No, because it is those in the registries are the ones who the public meets first, and that's where the corruption happens. And so they also tell us the problems they face in the registries, the secretariat, and the rest. So it is important for them to be there. The Judicial Council, yes, they are members. Yes. The association sends some, but usually they bring their president. And then, so as for the recruitment, it's really rigorous.
But I think the problem is that a lot of this is, if you are an insider, so you can tell us.
Yes.
There is no transparency in that process, right? So the other jurisdictions where either Kwekwasari or Professor Tuya is talking about, we know that there are interviews. We know that there is competitive recruitment. We know that you can apply because it's in the Constitution, and this is how the process looks like. But if the Constitution only says that the president shall appoint on the advice of the Judicial Council, and then you have to be in the Judicial Council to know how the Judicial Council comes by that advice, then that is a black box that the public cannot, which is why we will assume that, okay, this person was appointed through some means we don't know. But the people of the Judicial Council know, right? And I think that in the interest of transparency, some of those behind the scenes processes must be prescribed by law so that we know that this is how a person becomes a lower court. I'm actually quite impressed to hear that the lower court judges that we are talking about, the positions are advertised, they apply, there's an exam. Well, but
it is actually
it
advertised.
is inconsistent with the quality of justice you are seeing there, right?
The truth of the matter really is that justice administration is an experience.
It's an experience.
It's an experience. You see, you can
introduce yourself.
My name is Nana J. Bafoa. I'm a lawyer. Justice administration is really in experience. You can have all the qualifications in this world, but if you don't have the practice experience, especially when it comes to justice delivery at that level, right, you may make mistakes. Because, for instance, when you look at the lower courts, it's said that if you have 3 years experience, if you are 3 years at the bar, you qualify to be there. So you can be put there, right? But for instance, if you have to determine matters relating to the rules of practice, it has to be from experience. Even though at that level there is flexibility. If you have to determine matters, relating to, let's say, commerce, borrowing and lending, at that level, if you have not really practiced, there will be a problem. And that is why we keep having problems in our courts. Because oftentimes, now what is emerging is that you have a lot of judges who don't have serious practice experience. And that is where the problem is. If the person has practiced over and over again, over a period of time, and then he's determining a matter, he brings to bear a certain perspective, right? But if the person hasn't, he looks at it with a certain perspective. For instance, take our commercial court.
It's not practice, it's just 3 years at the bar.
3 years at the bar. 3 years at the bar. Take, for instance, a judge, very respectfully, who is promoted from our district court to our circuit court and subsequently appointed to the high court, and he's put at the commercial court. That judge may not have practiced his whole life. He may not have even had any job apart from being a lawyer, and subsequently joining the bench when he was 3 or 4 years at the bar, when he had not had an opportunity to do even a full trial. And the person goes to the bench. Subsequently, he is elevated by way of appointment and gets to the high court, goes to the commercial court. So even when he's delayed, a case is being delayed, that person might not even appreciate the ramification on the businessman who, for instance, has taken money and has to pay at a higher interest rate. And so all these dynamics, they are not answered by the current appointment process, where a judge will have to write exams. You go and write exams, civil procedure, a little learning, you may appreciate it, will be able to answer questions. But there are oftentimes gray areas where, for instance, judges, most of our laws in Ghana, they are discretionary, especially practice. The rules they are all discretionary. And so it requires a lot of experience to deliver justice in Ghana, right? As we sit here, even when you ask a judge in Ghana, what constitutes exceptional circumstance for the grant of, let's say, stay of execution? Nobody can tell you. Yet you go to the Court of Appeal for stay of execution and you are refused, and they say there is no exceptional circumstance. And nobody can tell you. You see? And so I think that what my lady just said, yes, is the practice. Previously, that practice seems to have brought some quality previously, and we need to admit it, where lawyers were recommended by the bar and so on and so forth, because they were very good quality. And you have senior lawyers at the bar, sometimes the president of the bar, approaching you to say, we have observed that you're a very good lawyer, so why don't you go to the bench? We are recommending you for appointment to the bench. That was very prestigious. And so some lawyers felt, yes, let me accept it. But times have changed. It's no longer like that. If you recall, I think 2015 thereabout, there were a list of names that came out for appointment to the Supreme Court. The Bar Association, in its own perspective, thought that certain people should go, some people should not go, and it became something else. Subsequently, it has even come out that the views of the Bar Association is not as weightier as it used to be. And I think that this constitutional reform offers us the opportunity to cure that once and for all, especially because the kind of law we have in this country, there's so much discretion that if you don't have quality justices at, dispensing quality justice, quality judges dispensing justice in our courts, then we all have a problem, right? I mean, prior to judgment in our courtroom, prior to judgment, every single application you bring to the court is discretionary. Even trial, admissibility of an evidence is to some extent discretionary. Because even where the rules of evidence says that this evidence is admissible, right? The rules of court at the same time says that a judge may refuse it on public policy grounds and other stated reasons. And so even our rules of evidence is to a very large extent discretionary. And so there's a lot of room for abuse. And that is why we need quality judges. And in my humble opinion, we need to follow the emerging practice in other common law jurisdictions. I mean, if you look at Canada, for instance, there has been a reform which was applied for the first time in 2016, where you have a committee of independent people, right, identifying people for appointment to the Supreme Court. I wouldn't limit it to just the Supreme Court, because I think that oftentimes the concern with appointments to the Supreme Court is because there are constitutional cases and so on and so forth. But the cases that actually also affect our day-to-day lives go beyond the constitutional cases to employment-related matters, to commercial matters, to criminal matters. And
so on this matter of discretion. So Professor Sari proposes a reconstituted Rules of Court Committee. Do you think, I'm sure you were here during his presentation, does that offer an opportunity to deal with some of these problems? Because judicial discretion is very difficult to actually get a handle on. Of course, there's an abuse of discretion standard. You can, go for review on abuse of discretion, but I know that too is probably discretionary. It's going to be difficult. But does that offer an opportunity for the profession, together with the bench, to cure this problem of just unregulated discretion in matters that are very, very fundamental to justice? Does the Rules of Court Committee reform offer us the route through this process to do that? Where would you do the reform?
I think that the Rules of Court Committee reform may help. And in reforming it, it should be informed by what the judicial administration or justice administration is. It's a service. It's a service to the people. And so representation on the committee should reflect the users of the service. Judges.
So you put users, court users on the committee, because Professor Asari's committee only has, if I put it,
judges and
it has judges, 2 lawyers, 2 faculty, so it has just purely the profession, right? Academics, practitioners, and then
I think
judges.
we need people from the general public or even the business community.
Well, they are not the only ones.
You cannot have everybody within the public, non-professionals or academic represented. But you can have a fair idea as to who are potentially the regular users of the court and have them represented. Because it is a service, and that is what it ought to be.
Okay. All right. Attorney General has been quiet today.
right to be.
Oh, I know we have quite a lot to talk about, but on this issue of the supervising High Court judge, you know, if you look at the Courts Act, you know, sections 52 coming, you find a lot. Monthly list to be sent to the High Court, power of the High Court to revise decision of magistrates. They are all there, clearly stated. The powers that he can exercise. So it's not like those people sit there and do their own thing. If this, you know, list.
On paper, is it in action?
Oh, it is. It is in action.
Revising these.
As to whether they can take care of the load is another matter. But it's all there. It's all clearly stated. The power to set aside the conviction, in which case the person, if under detention, shall be immediately released from detention, and any fine already paid shall be refunded to the person fined, and any security given shall be revoked. See, release. All these are there. But the problem I find, which I always complain about, is the development of this country, which is uneven. So everybody is rushing to Accra. And you sit in Accra, you see the things happening, you think they are also happening in the villages. They don't. Our experiences are all informed by our municipalities. You live in Tamale and you see a lot of things happening in Tamale. You think that is what is happening, maybe Wale Wale or some other place. So that is our problem, the uneven development of our country. So some of these things work beautifully because she is sitting in Koforidua and the courts around Koforidua, they know where the High Court judge or, you know, supervising High Court judge, they quickly will bring it. I don't know the other areas, maybe Kukurantumi.
From our front place, they all come, all the districts.
Yes, but sometimes they may find it difficult coming, whilst maybe those around, you know, can come quickly. And I remember when I was president of Greater Accra, we decided that our supervising High Court judge will be the Chief Justice. We will go to any other court. So we'll go to him and complain to him. These bail matters and what do you call it, amendments that take a lot of time. We'll go, Justice Abba, why are you sitting down looking at this? Somebody just want an amendment and it's taking so long. He said, don't worry, we'll talk to them. We'll see what to do. We were complaining to him regularly. Anytime we had a problem, we'll walk to him. So there was also, I think, then the Bar Association, he doesn't know well the role of the Bar Association in this judiciary. We've done quite a lot of work. Some of the recommendations that we have made, even when it comes to appointments, we said we know those who collect bribes. So we practice before them. So we are the people to go and say, my friend, don't try. This man, or this woman. Women don't do it, but this particular woman.
Are you still doing that?
Oh, don't go there.
I mean, is this current job that GBA is doing, or you stopped doing it a long time ago?
No. We've been doing it. I don't know, you see.
Really?
With time, as we grow, we seem to see the younger people as inexperienced. But we all were also inexperienced when we came. With time, we acquired the experiences. You know, so they are there. You still have the Bar Association playing their role. And it is the role they have played generally that led to their recognition in the Constitution. That you find that every time they say a member of the Ghana Bar, it is not for nothing.
The Constitution.
Sorry.
They wrote the Constitution.
They did it.
They wrote themselves in.
In fact, 92, we were not there. It was after they had finished.
You were there. You were not officially there, but most of the organizations that appeared there ended up sending lawyers to them. So the bar was not there institutionally, but there were a lot of lawyers involved in the making of the
I can assure you, just before, when they brought out the first draft, we said, Charlie, we are those who will work with this law, so we are going to hold a conference. So we held a conference, went through it, and presented the paper. I've always been telling them, they keep saying we drew and didn't. It's not true. We met at the law school, And we brought in all the ideas that we could, which we sent to them. So like I'm saying, a lot of things that our brother Azar is talking about, in terms of practice, you know, we have found ways of doing that, but perhaps...
Isn't that part of the problem, right? Because what we are trying to do, right? So yes, there's practice. If there is good practice, why don't you prescribe it, right? So you can go to, if you can, with your influence as, you know, Greater Accra GBA boss, you can go to Justice Urban and say, we want you to be our supervisory, whatever. But so it's almost like it's basically ad hoc. It depends on who you know. You go to. If there is a good practice that can help solve that particular problem, why don't you just prescribe it in the court and say, this is how this lower court tier is going to be governed. And if it's in the Court Act and it's a very short thing we can lift and put it in there and it's elegant and it works, put it in there so that at least we have in the Constitution something that everybody understands is how this court tier is going to be regulated. But if you leave these things to practice and this is how we do it and it's nice and it works, but it is not law, right? And so some of these things, I think that is part of the problem. So even with the Public Services Commission, so we have all these things in a policy, but the policy is not law. The Constitution says do this by a constitutional instrument. You are saying you have a policy document, you know. So some of these things I think, you know, are good practice, but then why don't you just lift it and put it in the Constitution?
Well, I agree with you. I mean, a good senior would tell you that you don't learn the law, you learn the practice as well. Because the practice is as important as the law. So if you don't get to know what the practice is, you know, then you may be going the wrong way. So that could also be done. And partly of judges, for example, you know, we have the electronic selection system. It's only at the Supreme Court, I don't know before you left, if it had reached there. But they were saying that it's only the Supreme Court.
So it hasn't reached.
Which they don't have.
Even the selection has been corrupted.
I know.
Any high tech can be corrupted. So even they suspended for a time. It was corrupted.
So
it was corrupted.
I know we brought it about. You know, the first time I got to know about this corruption was when some people came to tell me they are going to get a particular judge to sit on their case. And I said it won't happen. We went, the judge was sitting there. I said, how? He said, oh, you have to see the electronic people. They will do the selection. They bring out the names like lottery and put it in a thing. And then it will select one. But they don't have to maneuver it. And it will come, it will drive. So this judge will sit on it, don't worry, let's go. And we went, he was sitting there. I've always been saying that when lawyers say judges, some judges are corrupt. It is the judges themselves that make the mistake. Because they tell the clients who come to them, when you go, tell your lawyer, he shouldn't talk this way, he should go here. The first, you know, if you are smart, you say, a layman telling me that I shouldn't go here, I should go here. Then really he has gone to see the judge. He has gone to see the judge. These are all the problems we have. So the selection is there. But if he thinks there is a way, a better software, which cannot be manipulated, fine. But we have the
I think that is where he's coming up. He's coming with this idea of the full bench sitting. As much as possible, let all the judges who are qualified by way of having no conflict of interest and therefore not to be recused sit on a case. It may sound a bit burdensome, but that I think takes care of this problem, right? If you start empaneling and choosing people, it's like you're doing forum shopping. You are the Chief Justice. You're not supposed to forum shop on your own court or on any court. But if you start picking, this 5 people should go and sit on that case, and then somebody never sits on any important case, you're like, but why? It's almost like you have been appointed, but the Chief Justice can basically almost indirectly nullify your appointment. You are a justice, but at my discretion, you sit on a case.
No, I agree. I served on the Bar Council, the Judicial Council, and all those things, General Legal Council. And we had occasion to talk about it. I was National Secretary of the Bar. the numbers at the time, there were many. So who were saying that, like the American system, if it is 8 or whatever, 9, let them sit. Let all of them sit. I think the time we started agitating was we reduce time. And then he decided that why don't we, for constitutional matters, have a higher number? But because we still have this review matter, leave somebody or two of them to come and add on. So, and again, for some time now, judges don't sit to give full judgments. They only give you the conclusion, and then they write.
We call it synopsis. In fact, I started training them that instead of us going to sit down and read all the judgment. So even if you are on my panel, I'll show them how to synopsis, because something I learned at the UN. So synopsis, so that they will know it's an art. The decision and how the decision is based. So you can have 1 page or 2 pages.
And then the full judgment comes later.
But before you do that, I insist that the judgment is ready here. And then we tell you to go to the registrar to collect. So most of those who sit with me on the panel say I push them too much. I say yes, the work is for us to do. So when you read the synopsis, then we say go downstairs and collect the judgment.
And you see, in those days.
And then if you give a dissenting judgment, I insist that the whole panel sees it. Because sometimes some of the judges will put in their coat, the men in their coat pocket. Then after the majority, what we have agreed on is read, then they will pull out their dissenting judgment. Whereas you have agreed to that dissenting judgment if you have read it the day before.
Yes.
You could have persuaded somebody to change their mind.
Yes.
Wait, you can write a dissenting judgment without conferencing with your peers?
No, we conference. And then we agree on what we want to do.
That's right.
And then either the presiding judge will say, you write it. Because from a discussion, we know that you have researched a lot. And then you bring it, and we read it and decide, and we shape it. And then in the course of the discussion, if you realize that somebody has a strong dissenting view, then I will say, write it and bring it, and let's read it. So sometimes it can happen that we can have a consensus and combine. Because it may be perhaps instead of bell aqua, it may be another water, but it still is water. But then what is not good is for you don't agree and you don't voice it out. And then when you go and read the judgment, and then you come and read yours.
Prof.
Yes, and meanwhile, we said, meanwhile, let's say we say, I agree, and if it is you bring out, you say, you don't agree. Then you bring out your, it has been happening.
Prof.
So I always insist when I'm presiding that if you have a dissenting judgment, let's see the day before, at least.
Is that not regulated by the practice on the court? So doesn't the Supreme Court have a practice by regulation as to how decision making on the court is to be made?
Yeah, but what I'm saying, some stubborn judges, a stubborn judge may decide. A stubborn judge may decide that this is it. But for some of us, after we've read the judgment we agreed on, and you go home and you don't agree, in the night you sit down and type your view and send it by email to the one who is writing the judgment. He may say, okay, I will incorporate it, or I don't agree. So then that way you embellish it and bring it, and then we all know there's going to be a dissenting judgment. And the most painful thing is that sometimes there's a dissenting judgment too. And then we are a panel of 5, and we have got 3. So we know that dissenting view will now become the majority. And then we go, and then the one person who joined decide to go to that popular side. That was on stay of execution. Because we were refusing stay of execution, in that they say there's no exceptional circumstance, or what is it that you are preventing? Because there was already established judgments where the Supreme Court, from experience, do not grant stay of execution. Yes. So we said that we have to offset that. So 2 of us, and then we got a 3rd to join it. But when we went, the 3rd person chickened out. So when new members came, the other one who joined me retired. So I told them this is the position. So they said, okay, if a case comes, we'll join your side. But it happened that I never sat on a panel with them until I retired. And those who agree with me happened to be on a panel. So this time, those decisions have been reversed so that there is now justice. If you can satisfy the court that they should stay, they should stay. So it is this.
Yeah, but if it happens at the Supreme Court, I mean, of course, I mean, why can't you do all this by regulation, and it's clear this is the process by which we make decisions, this is how we do it, we'll have a conference if you disagree.
Yeah, we have conferences.
Yeah, but I'm saying that the idea of somebody
Prof. Chair,
ambushing you.
I think that this is why your commission is very important.
Yeah, but you can't do everything by constitutional prescription,
no,
right?
But Prof, we can say that by regulation,
these things should be done by regulation.
These things should be done. Prof, when you look at the English Supreme Court now, Prof, I know you love Kenya, but if you follow the English Supreme Court now, you will see that even those that we claim to have learned from have reformed. They've reformed. You know, things have changed with the English Supreme Court. Ours, I think that it helps people. There are people, because in Ghana it's all about interest. We need to face it. And there are people whose interest these things serve. I think a lot of our problems will be solved if, one, the mode of appointment of our judges from the High Court to the Supreme Court is changed.
In what way? What do you recommend?
I recommend that we follow the evolving practice within the Commonwealth. Which is Canada. One Canada now has an independent commission, which is set up by the governor, the Lord Governor, who then appoints the judges. In the UK, the Lord Chancellor also appoints an independent commission that also appoints, identify judges for appointment, as opposed to an endless power, right, by the president to appoint. If you look at our constitution, where the appointment is under advice or consultation with the Council of State, I think that the Supreme Court, if it had seized that opportunity of making that consultation binding, or the advice binding, would have made a lot of difference. But it looks like we missed that opportunity. And so we need to reform it, because I don't think the framers of our constitution merely were anticipating an advice which can be rejected or taken at the discretion of the president. So I think that we need to reform the system whereby a group of persons, be it the Judicial Council, be it a body set up by the Constitution, different from the Judicial Council, will now select or identify people for appointment to our superior courts. And I think that by so doing, there should be an advertisement. There should be an advertisement like they do for the university vice chancellors. There should be a matrix, which is the regulation, which looks at the kind of criteria you have to satisfy. And so when the person is going for the interview or taking part in the process, he knows what he is up against, not something which is pulled out at the discretion of anybody. I think it will help because, one, we know that scholarship is itself a check on a person's conscience. Scholarship, it is itself a check on a person's conscience. When a person is a scholar, well-trained scholar, be it a practitioner, be it an academic, wherever the person is coming from, and the person goes through a process as rigorous as that, and he comes out, he's proud that he's not going there because of anybody, so he doesn't owe anybody.
Isn't part of the problem also that these, I mean, long before I studied law, I was reading law reports and all of those things, you know, even before Legon. But you don't find them, right? These days, most of these decisions, you don't find them published, right? And a judge that knows that his or her decision is not going to be widely read or widely accessible, I think would make a judgment quite differently from a judge who knows that as soon as I issue my opinion, people are waiting to read and critique it. So the judicial reporting, the law reporting side is very critical, and law publishing and all of that. Why is it that with all the technology, if you can publish it in a book because it's too expensive, I mean, this...
Prof,
No, you mean law reports?
Prof, if I may, Your Excellency, if I may answer, Prof. The Supreme Court,
This internal evil is that you don't even have the sufficient knowledge of the law. Therefore, you're unable to attend to the cases that are put before you. So sometimes you have to leverage on outsiders. So I have this matter which is, then, can you help me? And it's something that we all should acknowledge, that there's a serious practice where some judges give judgments to people outside to write for them. That is part of the knowledge we're talking about. So it is not that the judiciary is going to interfere. It's just because you have no capacity, you interfere yourself. Now, the second point is that there are people, there's a practice, and of course, there's some research from Japan, where top judges tell junior ones at the lower part of the court what to do. That's not the executive. That's not legislature. And that is not corporate bodies. This is the internal evil that we are dealing with. So if you're dealing with decisional independence and you're dealing with Article 127, will there be an instances where a person can assert his independence or her independence in relation to this practice? When can I refuse orders from a senior judge who might have influence in respect of my promotion?
This is part of the reason why the Kenyans changed this practice of having the Chief Justice being a member of each of the tiers of the superior courts.
Yes.
So you know that before 2010, Kenya, like us, had the Chief Justice being a member of the Supreme Court, the Court of Appeal, and the High Court. After the 2010 Constitution, the Chief Justice is a member only of the Supreme Court. So that vertical control that the Chief Justice was exercising over the subordinate judges,
yes,
at least part of it is cured,
yes,
right? And so one way to cure it is, which is Professor Azar's proposal, the Chief Justice is a member of just that apex court. Yeah. The other way I think his proposal helps to cure it is in
Prof, what he's referring to...
Asari's proposal does not deal with judges' interference on judges.
Exactly.
Asari's proposal does not deal with... Yes. So in terms of proposing a rule in respect of...
You can't cure all of it.
No, Prof. You ought to be clear with that. And with the appointment process, as you said, neat appointment process.
How would you do? I'm interested in...
Prof, let me assist.
No, I'm interested... No.
So,
I'm interested
in that 127,
independence
instead
issue.
of saying, of course, if you read clause 1 of Article 127, it says in the exercise of judicial power, the judiciary. It didn't say the judge. You understand? It didn't say the judge. So most of these people are saying that when we say the judiciary, it's actually it's a reference to the institution. So I can call you and tell you what to do. So senior ones down there, this man is up to appear before you at 9 a.m. You know what to do. And there's nothing. A judge.
The judiciary.
You could have A and B.
Sure.
A being the judiciary.
Exactly.
B being the judge. Now, in respect of appointment and quality, as my senior was talking about, the appointment processes, advertisement. One of the states in India was dealing with problems in terms of quality of judgment or quality of judicial decisions. They conducted a survey, and we are not actually open to this survey. They conducted a survey which shows that the appointment process for over 10 years, from magistrate, circuit court to the high court, the fresh appointments, these are the last 2% in their class of graduation. So they have third classes. And we are talking about quality in terms of appreciating, not just about practice. Do you appreciate the principles? Third class, a pass. And these are the people who are at the magistrate, coming up to circuit courts, coming up to high court in terms of promotion. There are people who might apply with, say, second lower, second upper, the first class, and they would not get it because of the transparency that you're talking about. So in advertising, can we be clear about the eligibility? Who qualifies? Can we be clear about academic eligibility to start with? Should we say you must have a second lower? Or should we say you must have a third class? Or should we say you just should have an LLB? Because it's always blank. You must have LLB. Third class is LLB. A pass is LLB. So if...
That is plenty.
You say?
This is the first class. You guys, you give it plenty.
Now, and this runs into the quality, because you can't deal with this matter in isolation. Because those days, it used to be only one faculty. Now we have multiple faculties that when we're dealing with checks, in terms of who gets appointed to teach, the Judicial Council is not doing that. The Judicial Council is not able to do that. The General Legal Council, for some time, is trying to talk about recognition of faculties. But GTEC is, on the other side, pooling. GTEC says, we are the people who are going to give accreditation. It is not the General Legal Council. General Legal Council says, okay, you can give accreditation for the LLB, but we may not recognize that LLB for the purpose of training to enter the law school for that kind of training. So how are we going to discipline that issue? It may not be a constitutional review matter, but in terms of auxiliary acts of parliament, which is connected to this. Because you may have a strong constitution. If you have a weak court, you're not going to have anything. A weak court with a strong constitution gives nothing. Probably a weak constitution with a strong court can give something. So the quality is very important. And that runs us into, when you say appointment, the person must be a person of high moral character and proven integrity, and not less than that, standing at the bar. And standing at the bar is defined. Standing at the bar. So, and of course, the minimum definition is that you pay your annual bar dues, and then you pay your annual renewal license, so you are there. So if I graduated from, let's say, the Faculty of Law, University of Ghana, and I've been selling timber for 10 years, and after 10 years, I qualified. And in fact, I've been paying my fees and renew my this. Nobody tracks where I am. You don't track where I work. I think that needs to be, if you have to be detailed enough in terms of catching who qualifies to go there. Otherwise,
what would you add to
the practice? The practice should be
number of years on the bar.
Demonstrated area of practice. You must demonstrate an area of practice, either civil, criminal practice, academics, something of that. So that's practice, or judge.
Practice, yeah.
But this
appointment authority, it is considered.
Good. My lady, the standing is omnibus clause for us.
Yes, but that's how it, so even I remember one time, one veteran of a Supreme Court judge, they were saying he has seen practice. So there was a ding-dong, and he was saying, okay, he was a lecturer, and it's all considered as at the bar, standing. Yes, so it is there.
I agree with that.
For the appointing authority in the judicial service, which matters.
I'm talking about the clarity of the phrase standing. The clarity
so
of the phrase.
So what's your distinction?
Yeah, but it is a practice that is, I mean, it's not prescribed in law that you should do it, right?
My lady doesn't get
But Prof. Chair, that was why I proposed. That was why I proposed a regulation. A regulation that would take care of the appointment criteria.
Yes.
That was why I made that proposal.
That much. I'm just feeling you in that. I agree with you. Yes.
Professor Tupari made a very important point, which is that quality is important, but there's also sometimes the propensity of internal influence.
Yes.
And that for me is very, very important. And you also fleshed it up by saying that it oftentimes happens because of, the prospects of promotion or, being elevated. And so you have judges who are supervising lower court judges. You have judges who are constituting disciplinary committees for the purposes of disciplining a judge. And so they are then looking out for themselves. And so if we want true judicial independence, and from what Professor Tupari said, it really highlights the fact that judicial independence is not necessarily independence from just the executive and the legislature, but internal independence. And the internal independence is compromised where a judge is subject to the authority of a senior judge. How does that happen? When there is the need to discipline a judge and you are constituting the disciplinary committee and you are going to have senior judges being part of the committee or dominating the committee, the judge then will be thinking about himself. Charlie, this man says I should do this. Let me be careful. If I don't do it and tomorrow I'm in trouble, and he has to supervise or be part of the disciplinary process, I'll be in trouble.
So you're looking for an independent body to deal with that.
That is why I am highlighting that we need to go the English way in terms of.
But if you change the appointment process through the hierarchy, say from circuit or bar to high court, from high court to court of appeal, from court of appeal to Supreme Court. If you change it in such a way as to remove the individual control, for example, that a Chief Justice has in those decisions, that's one way to cure it, which is why you remember when the Chief Justice proposed that the Supreme Court be expanded to 20, and that she had proposed some names. There was some reaction to that. Because if you can single-handedly determine who you get picked up through the process, then of course every other judge below would know that if you catch the eye of the boss, this is how your career is going to be like, right? So the appointment process at the lower level and the extent to which it depends on the say-so of one boss or the other has a good effect on this. And so I think that if you take the totality of the proposals that Asari is putting up, that Appiah is putting up on these appointments and together with them paneling and the full bench, they will cure a lot of the problem, because it's not the Chief Justice's role as a jurist that is problematic. It is the administrative powers that the senior judges are able to use over the lower ones that compromise their decisional independence. So I think that is where we should. I don't think now, when was the military regime period and all of that, the fear of the bar was institutional independence. How to make sure the judiciary as a body is not, at the beck and call of the polka class and all of that. Now I think the growing sense I'm getting from you practitioners is that the bigger threat to independence is internal.
It's internal.
And if it is internal, then basically all the politician has to do is just get one boss, and then they control the whole
Exactly.
system.
Even in reference to Asari's proposal of the 9 justices, I think I like that. But we have to distinguish statistical relevance of that argument, which is that we just have 9, and we have 9 because there's a presumption that it boosts that kind of debate and things like that. But if you have a court, in terms of practice, that promotes singular voice in terms of writing, which is that we have sat, we look at the matter, and we're saying that one of you should just put an opinion. We all say, I agree, and then we go. To what extent are we developing law with that? So you cannot. Even in the case of the majority, you realize that we enjoy reading her opinions, not just because she's here. Asari mentioned before an Attorney General, he mentioned other cases where we have seen plurality of voices. People are not being dissuaded from writing concurrent opinions. So if I put these 9 justices and we do not get the output in a very proper context, it will still not be relevant for me. It is just about statistics, not about quality. And that is where I might disagree with him in terms of whether we should have a constitutional court or we should not. I believe that we should have a constitutional court because it's a specialized. And
so how would you do it? I flirted with the idea a little bit. This is why I put up the proposal of a constitutional division of the Supreme Court. Right?
Yes.
So that it doesn't become separate. In Uganda, it's separate from the Supreme Court. It creates
Yes.
a problem.
Yes.
There's a constitutional court that is subordinate to the Supreme Court, and then you go there, then you go to the Supreme Court. But if you have the same Supreme Court, and you say, and partly because you already have numbers beyond 9, beyond 11, you are not going to be able to dismiss them, right? So you have 19 or so justices. Assuming that we were to just stick with 19 or 18, it's a huge number for me. But if you divided them up into 2, and you say there's an appellate division where all the appeals on the appellate side will go, and then there is the original jurisdiction division where they will do the constitutional cases. That maybe it would mean 9-9 or 8-8 or however you do it. The Chief Justice is a member of both. You don't have to create a new court in that formulation. You still deal with the same Supreme Court. You are just parceling the jurisdiction.
In that case is good.
Somewhat?
In that case is good because we are still consistent with this British system. Because in the House of Lords, they have divisions. The Chancery, criminal, and what have you. They have them. It is just how the nomenclature that we adopt in terms of what we want them to be referred to. So if you want to say the original jurisdiction division or whatever you want to term it, just for public law questions, relevant public law questions, in this case constitutional questions, I don't think it is bad for us. And one of his arguments for saying that he doesn't support it is because it would take away the judicial review culture that we have, which is unitary, and I don't think so. The culture is unitary, and it's just that the divisions are different. This section is going to handle these questions, and this section is going to handle this. And you must do so, take into account culture of litigation in this country. When he's comparing the numbers, he says this state is 2,000. In our case, the Supreme Court says it's 600. The culture of litigation in this country, there's one case before the Supreme Court. You might have some 10 motions which might be carried before those 600 cases are. So you're going to multiply numbers. So it's no longer that case which is pending. It's now babies, which are part of the stress of the, and it's part of the list that we should admit. Elsewhere, when you have the 2,000, it's the 2,000 straight. The culture of litigation there is different. So in my case, to discipline the process, in order to have the Supreme Court performing that role, which is the policy court and a court of justice, in having a coherent voice when it comes to a principle. Otherwise, today is this, tomorrow is that. And when you're even teaching, you don't know what you're teaching because you don't know what will come tomorrow. And that is very important for us. So when we have a division which is going to deal with constitutional law questions, we know when they are going off, we can track them and say something. And then you will be able to monitor in terms of where they progress. So I don't really care if it's the divisions, but we should not miss that point in terms of trying to discipline a structure that will bring us the fruits of the law.
Pio, let me just find out from you, in terms of the divisions, would you recommend that we have, let's say, civil, criminal, and constitutional? So far, we've spoken about only the constitutional. What are the other divisions?
So we have been, let's say, the equivalence of chancery, which we have in the UK, criminal, and then we can take constitutional law divisions. So we can have 3 divisions.
Partly to deal with the size, right? Because it's so large, and because our court has, I think, gone beyond a size that is reasonable for the country and the economy and everything that we have. But you can't bring them down by force. The number has already exceeded.
Yeah.
So doing this division thing is probably just a response to a reality. It's already there. I don't know that we can continue to parcel up the court that way, right? The court's jurisdiction at the Supreme Court level is broadly appellate and original. Maybe if we have 2. But if you start then parceling them into appellate civil division, appellate criminal division, appellate, maybe if the numbers go too high, if they were 20, but part of the idea, and I think part of the logic of this thing is that it also, the incentive to empanel grows when you have a large court. If you have a large undifferentiated court, 20 judges cannot sit on the case. You have to empanel. So I think part of the appetite for the empaneling or for any Chief Justice wanting more judges is that the larger the number of judges of the Supreme Court, the more your power to empanel grows. Because if there are 5, if there are 9, but if there are 15, 20.
Prof, in respect of constitutional cases, we would not have original and appellant jurisdiction.
So we just have original.
So we just have original.
So maybe the election petitions go there because that's also original, and then
we might also have referrals. Yes, questions arising from
ones.
That's all I would have stuck to say that this is public law, constitutional law issues, and that's how. But the others, why I'm saying so is because, like some faculties would do, law faculties, when they are employing, they don't employ it based on. There's no need-based employment. So they bring international conflict of laws, conflict of laws, 9. Each of these is now forced to go and teach tort, contract, constitutional law, jurisprudence. And that is where the struggle began. So if you have these discrete divisions, it places a kind of, if not legal, moral obligation for us to determine who gets there, who's going to go there. You cannot be doing banking, insurance, and you are appointed to go and be on the Supreme Court at the criminal law division. What will you do? What fruit will you bring to the Republic? Right? What fruit will you bring to the Republic if you are sitting as a company secretary into corporate affairs, and then you are made a Supreme Court justice and you're going to the criminal law division? It will not. People will begin to see things, to say that, hey, this behavior is not, good for us and that. And that's why we can even track the criticisms. Otherwise, we now become political. We don't like her or we don't like him. And secondary school reasons will show up, not necessarily what is current for us. So I think that taking the divisions will also even discipline the appointment process in terms of quality. Sieving is a sieving process. You can't just get anybody there. You've been practicing for 40 years, it doesn't really matter.
So in that case, would you appoint to the constitutional division and appoint to the appellate division separately?
And they should be clear. Yeah, they should be clear on the appointment. I know, Prof, in U.S., when Supreme Court justices nominees appear before, they are forced to tell us schools of thought in terms of interpretation they belong. None of our justices have that obligation. And this is where we have the struggle in terms of coherency of principle. So today, he's a natural lawman. Tomorrow, he's a positivist. Then, years to come, you see him being sociological school of jurisprudence man. And you don't know where we are. But when they say, I am originalist, they are originalist. If he says, I am non-originalist in terms of interpretative schools, you see that they are. And this is where we can say that, hey, you told us at your vetting that you are originalist. What are you producing?
Yeah. Okay. Prof, Prof I think, if I may very respectfully, Prof, I think that...
Yeah, no,
I think the Justice also wanted to either respond to you directly. Okay. So you are done.
Prof, okay. If I may chip in something quickly.
I will recommend 15. Maximum 15.
But then I know that if they want to make ask the judges to make a choice, most of them will opt for constitutional jurisdiction because the civil and the criminal appellate jurisdiction, there's a lot of work there.
You would have shown, if you go for constitutional, you would have shown your qualifications.
Yes,
Prof,
yes.
It's not a personal preference.
That's what I mean. A lot of people
I will go for.
will move to that side because that one, then the whole world will know that you are eminent and you can write. But they know if you choose criminal, it means that you are.
No, it's not criminal. It's appellate. You are the apex court.
Please. Because it happens that when we go on appeal and they are impaling or even writing judgments, let's say when it comes to criminals, all of them will tend to those who were known to be criminal law practitioners or those who came from AG's office. And we felt insulted because we are well versed in other areas too. So we refuse to do the criminal cases. Some of them, they don't mind because as for Bamfordado, she said when there's a criminal appeal, he knows he has to write. And me, I refuse to write because, because I want also to demonstrate that other areas too, I'm very competent because, so that is how it is. So if they want people to make a choice, everybody will go to constitution.
But I don't think that we can allow people to make a choice. If that is how we go, then the qualification for whatever criteria would have to be spelled.
Prof. Chair.
You have to be named.
And then when you go for vetting, and when you go to vetting too, those days, nowadays it has changed. They want to know how well you are versed in constitutional law. Yeah. So I remember at one time, one particular court of appeal judge that I haven't gone to the bench was not recommended because they said he's too conservative to be allowed to go to Supreme Court to interpret our young constitution. That time we have passed the 1992 constitution. So he wasn't, he was vetted, but it was never recommended. And it was getting to the end of term, so it means that it lapsed. Some of the others were approved. He was not approved. So he remained at the Court of Appeal until he retired, because they said he was too conservative to handle our new constitution. They want people who are, so that is it. So those days, the parliamentarians wanted judges or people who can interpret, have liberal area of the constitution, not conservatives.
Well, I think we've all stolen Professor Appiah-Tua's time because it is his remarks that provoked this conversation. So we'll give him the balance of the time before lunch. We'll come back after lunch. So he will have the balance of the time to respond to all of these things. Thank you. Sorry.
Thank you. Thank you, Mr. Chair. Yes, I think the discussions have been very interesting and very, very useful. I was going to talk about the decisional independence, and I'm glad Professor Tupari has brought that in. And I think we also need to factor in the role of senior lawyers in decisional independence as well, because sometimes they can also influence the decisions made by magistrates in particular and circuit court judges. Yeah, so it's not only the senior judges that do that. In terms of division at the Supreme Court, I agree with that proposition. And I think, at least for starters, we should look at the original jurisdiction, constitutional, and then the appellate. And it should be based on experience and qualification. So if somebody is taken to the appellate, then that person knows that that is where I'm going to be, and that
maybe you should also address the workload imbalance question, because clearly there is more work on the appellate division side than on the there would be on the constitutional division side, if that is what.
Yes. So in that sense, I'm saying that even if we say we're going with the 15, there should be more on the appellate side than on the original jurisdiction side. Yes. In terms of the other question that was asked, Reina raised a very important point about the fact that there is corruption and maladministration and a lot of issues at the lower courts. And so we shouldn't pay a lot of all the attention to the superior courts. And that's very true. That's why I was proposing the petition system where people within the community can make a case that this magistrate is not performing well. And that should be picked up. It shouldn't be a formal process that you have to do this and do that, go through this letter writing and so on and so on. So sentiments within the community should be taken on board in trying to deal with some of the incompetencies and corruption that take place at the lower level. And in that sense, there's the need to set up small claims courts that deal with small, little debt issues and so on. Yes, it seems to be lacking in the judicial structure. And I think it's very important. Somebody is owed $200, 200 cedis. That 200 cedis is very, very important for the person to survive. But how do you go and file a case when you have to pay more than 200 cedis to get the case? And that is where they rely on the police and so on to do debt collection. So I think if we can bring that in, it will also be very, very useful within the local jurisdictional settings. And I think we've also not talked about the Judicial Training Institute. It's very, very Judicial Training Institute. Yes. I'm on the board, but what I see is that we are doing a good job, but it's not very active. And I think there's also a lot of influence by the Chief Justice over how the Judicial Training Institute functions. So there should be a system in place where there's a lot of independence for the Judicial Training Institute to be able to function effectively. And it should collaborate more with academia so that academia can influence some of the trainings and so on at the Judicial Training Institute. Sometimes people are just picked, say one magistrate from here, one from there. It is not, it's kind of discretionary. Excuse me, so you are picked not necessarily based on, there's no fixed criteria. So at the end of the day, people who are picked for training may even end up coming again. And sometimes they come because they get per diem and so on and so forth. Yeah, so we need to structure it properly, and I think it can help deal with some of the gaps that we are talking about here. Excuse me. On the appeal, right of appeal, I think I see that is also it's something that is reflected in the Kenyan Constitution as well. And but of course, if you look at the Kenyan system, the process is a little bit different in terms of the role given to the Judicial Service Commission or something to start a petition on its own. But I think that body, to me, is more independent than the president playing this role in our constitution. So even if in their case, they still have the process of appeal, then maybe they might have seen something there that maybe there may be some injustice or maybe not a fair process taking place. Therefore, there is a need to allow some level, another level of giving the Chief Justice or other persons holding similar positions to be able to contest the case. And I was also referring to, I was looking at the South Korean situation where even though there's impeachment of the president, it still has to go to the Supreme Court to confirm it. So that's why I was making that proposition. So we may want to see if it will work or not in our case. The role of the GBA, thankfully, my senior has mentioned that, so I wouldn't comment further because that is very, very important. Yes, it's very, very important. We need to take it very seriously because in a lot of ways, the GBA also represents the voice of the people. Yes. And I'm also looking at a role for civil society organizations that specifically focus their attention on judicial issues, especially for the underprivileged. If they do a good work in supervising the work of the functions of the courts, especially at the lower level, I think when we come to setting up committees to review the disciplinary proceedings and so on, they should be put on such committees so that their views will be reflected in how the magistrates and other lower courts, how they perform in their jurisdictions. Excuse me. Yeah, somebody else already mentioned the role of the supervisory judges, because sometimes they also contribute to the incompetencies performed by the lower court judges, because they know that sometimes there is some sort of collusion that because I'm going to supervise you, when you I suggest to you in terms of the decisional independence we're talking about, you have to comply, because at the end of the day, I'm going to review your work. Yes. But what I don't see, I may be wrong, but it is only when the decisions are made by the supervisory committee, courts or judges. I don't know to what extent that these judges or magistrates come to know of it and how it influences their future decisions. I think that is very important. And also possibly if this is really clear that they did something wrong, they tampered with the judicial process or something, whether there can be some sanctions against them at that level, or to what extent that is taken into account when it comes into their promotion. But sometimes some immediate measures taken can also deter others from committing similar infractions. So I think that will be by way of my comments and reactions to the questions that were posed to me. Oh, I think
it's 2:40 already, and we usually have a window by which we should finish lunch. So can we go to lunch and come back, because you'll be back, right? So everybody is back here with us. Of course, he's joining us. He can't come and talk like this and not have something to eat. So we'll come back after lunch and then spend the balance of the afternoon dealing with these issues.
JTI. Yes, yes. Yes. We were on the JTI board.
So we'll
together.
take a break. on the judiciary, I think what I'm learning from the conversation is that sometimes these distinctions we make between what is judicial and what is administrative is oftentimes a kind of false dichotomy, because the administrative has a big impact on the outcome of the judicial. Right? And many of the things that we are discussing in the context of decisional independence oftentimes almost invariably come from the exercise of a power or function that appears on the surface to be administrative, and yet the consequence of which is always judicial. So you are deciding a matter, and then you are looking over your shoulder in anticipation of promotion through the hierarchy, and that, of course, influences, your decision. I mean, some of these things cannot, you can't help it. What we are trying to do here is how can we mitigate the ones that we can mitigate through the constitutional review process, and maybe also in the fashion of the Constitutional Review Commission of 2010-11, where we think that the matter is beyond constitutional prescription, then maybe make some recommendations for legislative or administrative reform. And I think that probably is true of a number of the points we are discussing with respect to the lower courts and how they operate. But I think that it would be improper for us to continue this practice of just focusing, when we deal with constitutional review, on the superior courts and just doing one sentence or paragraph on the lower courts where most people experience justice. So I'm hoping that some of these things we're talking about will find their way into the Constitution, so that at least we can give some protection, adequate protection to the people who live their lives and experience justice at that level of the judicial system. But I think this has been a very good discussion in the morning and early afternoon. I don't know, for the balance of the day, any other issues that we haven't flagged that are important for us to know. If you want to raise an issue, okay, we'll start with we'll go around the table this way. Elsewhere, the U.S. Supreme Court changes its mind and they are confident enough to say that this case is overruled, and then they give a new decision. And I think that culture, it could be a cultural issue. I don't know. I don't know why. Sometimes you read a decision of the Supreme Court of Ghana in one case, you read the next one, like, but this and this, they don't jive. So why don't you either say that we distinguish this case based on these principles, or we overrule it based on these principles? And I think that the absence of that kind of candor on the part of the court to say that either we erred or we have come to this decision separate, different from the, sometimes they don't even engage the other case. They don't even engage the other case at all. They are talking as if that case doesn't exist, when in fact the case exists. And this is why I think at Tufari's point, it's like we don't even know how to teach it. If you are a legal educator and you are teaching constitutional law, or even any of these cases that go on appeal, and you have these inconsistent decisions, how do you teach it? So I think there is part of the judicial culture. A court, the justice must be able to say that we made a mistake in this case, and in the subsequent case, this is what we have decided. This is the new law.
But is it because they don't have the power?
They do.
To do their own review, except when somebody goes. That's why I'm leading to.
Oh. No, but it doesn't
there a
even have to
way?
be a review. It doesn't have to come by way of a review.
Mm-hmm.
If you decide a case today, say France versus EC and Attorney General, and another similar case comes, raises the same Article 296C issue, and you say, well, upon reflection, we got it very wrong in France versus Attorney General. There's nothing wrong with saying that.
That one, I think they do, don't you?
They
do. A few of them, they do.
How many cases
They are able to say that we erred. But I'm saying, is it possible to give them authority?
But they do.
For them themselves to say that, look, this nuclear meltdown, which we did in 296, has just destroyed the whole policy of bringing about the exercise of discretion. So having thought about it again, we think, so the question is,
without a case over that one, it's not possible, right? They cannot, without a case, do that. But if you bring the appropriate case,
unless you bring a case before them,
absolutely.
That is what I see is the issue. That until a similar matter goes, there's not much they can do.
But other Article 296 cases have gone where they haven't mentioned France at all and have gone on to say other things. So there have been cases about discretion that implicate 296 where they don't even mention France, as if France doesn't exist. And then they go and say something else. This is what I'm saying, that refusal to engage in 296C case comes. And pretending that there is no problem here is my problem.
No, that is bad. That is completely
bad.
But
you have to engage France if you don't like it. But you see, when you decide a case 7-0, that is part of the problem. When you decide a case 7-0 and
the opportunity to read the judgment
it will be too tedious. If there's thinking of one or two people are the same as what we are going to, then what's the point? That
sometimes it's not really about the decision, but it's about how you arrive at the decision. And when you have many ways of reasoning, you will find that how one person got to the place will be the better one. And that's the wisdom in having all of them, or majority of them, writing. You will always see that one will stand out. And that could be the judgment that most lecturers will be referring to.
I don't know, let's seek the opinion of somebody who has worked there before.
I mean, you usually don't
Should
do that,
everybody
right?
have to write, even if you agree?
No, but if you say I concur, I mean, I think this is exactly where I'm agreeing with you in a way, right? You don't have to write an opinion if you voted with the majority and you kept quiet, and you are part of the majority. But if, in addition to having voted with the majority, you say, I have read my brother, my sister, this is the opinion, and I concur, then let us know the basis for your concurrence.
Everything.
But then don't say anything. Don't say it.
Even though that is the point.
Everything.
Don't say it.
Everything.
It leads to what scholars call judicial voting.
Judicial.
You say, but on this issue, I would rather say it this way.
Yes.
Though you are concurring, but you will say it this way.
That's right.
On some particular point. Yes, you can also do that.
But that is what the concurring opinion means.
No, they do. Some of them do.
Yeah.
In our context, we should be mindful of judicial voting. Because, as she said, there's nothing wrong with you saying that I agree with this decision or opinion, which has just been read. However, I have few ways to add. And this is how I put it. For the development of the law, you can do it in many ways. One, if there are multiple legal reasoning or reasons for coming to a particular conclusion, there's nothing wrong with you saying, take reason one, develop it. I take two, you take three, and we write. If I focus on one reason why the court came to this conclusion, we are all marching towards one point. It's just that we have multiple reasons in the particular case in arriving at that. There's nothing wrong with that. That's one issue. Another one is that even though there's one legal reason for coming to that conclusion, how I choose to put it is differently. So I agree with the conclusion you have come to, but I'm going to put it this way. So mandating them might be strong, but if there's a way of encouraging them to be good, because there is culture of judicial voting. I agree, I also agree, and that's why in paneling them, a particular Chief Justice will just be looking for who is going to agree.
Agree with me, yes.
Without writing.
It's true.
Because there is no obligation to write.
That one
There's no obligation to put down an opinion where people will confront you with that opinion. Why did you write this way? Something of that sort. So, the growth of the Constitution requires it. The growth of the Constitution requires it. That's why some people will say, we're not growing. We're not growing because we're not putting more flesh into these bones that we have, we call Constitution. You can mark it, do a survey. You may have a particular judge sitting there agreeing for the whole year. Yes. Or you see 60% of the year's job is done by one person, but somebody is there just agreeing. I also agree. I have nothing useful to add. And you can't be taking salary and doing that.
Yes.
You see, and sometimes you can't blame the judge who is always agreeing, because he is always perhaps number 3 or 4 on the panel of 5. Yes, and it's not mixed properly. So he agrees, because sometimes the presiding judge will say, so you still want to write an opinion? And I will tell you, yes. So it depends upon you, the judge yourself, if you believe in yourself. So you can even stand up to a Chief Justice who will say, so do you still want to dissent? I'll tell you yes, because I've already written my opinion, not that I'm now going to come and say I agree. And there are some too where one funny case, so I dissented. We were 5, I dissented. Then when they discussed that and they were not agreeing with me, then they asked me to write the judgment. Then I said, I'm dissenting. And this thing we have discussed, I haven't seen any written thing. So do you know the judgment? we dismissed the appeal. So the lawyer couldn't come on review, because what are you coming to review? And I didn't put in my dissenting opinion, because if it's only one line, what am I dissenting from? But unfortunately, the matter came again, so that's my judgment. That was what I used for the case. Yes, so because it was, so that one, it was, they say we are dismissing the appeal, and I'm dissenting. But on what am I going to dissent from? So that's the basis. So in that one, it may come that, okay, we are all agreeing.
Well, on this other issue of judicial secretaries being judges.
Oh, please, excuse me, this one, he wasn't he is a lawyer. They have always been lawyers. Yes. Then when they come there, then they see the opportunity to become
judges.
Yeah,
and then give up their judicial secretary position, or they keep them?
No, they still are there. That's what I wanted to explain. They are brought in as lawyers to act as judicial secretaries. While there, then they also seek promotion, and then they are promoted as Court of Appeal judges. Yes. So actually there is one who left the position and became, he's still sitting.
Yes, and then the one who replaces is also now a Court of Appeal.
Is now a Court of Appeal. So I don't
know
whether
that's a new practice.
I don't know whether they should also be promoted to Court of Appeal. I don't know what it means. What he came to do was judicial service work. So why are we promoting him or her to be Court of Appeal?
I mean, if you pick the person to the bench, of course you can pick people from the bar, the service, but they should give up their judicial secretary job. I don't see why once. So it's all about salaries. Every time it's all.
Some of us too have been advocating that we have a separate judicial service from the judiciary. And that judicial service will be headed by the judicial secretary, like in Kenya. So they go and present their budget and everything. So they have the budget for the judiciary. So they get more money than how here we don't have independence of financial. You're reading something. As for financial, we are not independent. We send the budget, it's also cut down.
Give it to you.
And they tell us that even before you prepare your budget, the Ministry of Finance say, this is the ceiling you can go. So they'll prepare it to the ceiling, but still by the time it reaches Parliament, it has been cut down. So we are not judicially independent. So the last constitutional review, we're asking whether we can put something in about our financial aid. Then they said they are not doing conditions of service. then we said, oh, this one is for the judiciary financial, because the constitution says you should not touch even our budget. But
what about the IGF?
The IDF, we are just like all the ordinary public service and civil service. So we
only for administrative expenses.
Yes, we retain a certain percentage, but even I understand it has to go to the consolidated fund before you get it. Not that if you get 200 CDs and they say keep 10%, you can keep the 20, so you can't keep it. You have to send it there before you chase it. So there's something you paid in December, you get it in April. If you're lucky.
We collect before we spend.
And they don't.
So first quarter.
They don't consider us that we make money. So what we are even keeping, the 10% is for the forms and the statutory declarations. But for the court fines and the rest, we don't get any percentage from there. So it's only from what the forms they've been selling, the affidavits and those things.
Yeah. Then the
so even that one we want to keep, they said no, they can't change it. So they raised it by only about 2% when I was leaving, to about 12 or 15%.
Now, this prima facie matter, assuming the person is dissatisfied, there's no procedure.
Well, that's what
he said. They should be able to appeal.
That's
but to which court?
He said the Supreme Court.
That's where I'm coming to.
Sorry. That's just like the Kenyans currently have it, right? But it's so the Kenyans have it, right? Article 1.
Mine is that we are stopped because of the in-camera hearing. It's because of the in-camera. So what do we do? Can't we do something about the in-camera? If you feel dissatisfied, this time you should be able to go.
And let people have the judicial. You can still be in the Supreme Court in camera.
In camera, that's what I'm saying.
That's what you're
saying. Even if they want to hear, they can hear in camera. Because Supreme Court has jurisdiction to hear matters, security matters, in camera. After he wants to know.
Okay, so my point is that the first step is establishing, dealing with the prima facie issue. Where parties may be heard to determine the prima facie issue. The second step is the setting up of the committee to make a determination on the case itself. And when that decision is made, as the Constitution stands now, that brings a finality to the proceedings. And then the decision is made whether the CJ should be removed from office or not. And I'm saying that if the decision is that the CJ should be removed from office, the CJ should be given the opportunity to appeal that decision.
Or the heads of independent constitutional bodies.
Yes.
So
they should also be given the opportunity to appeal and hear everything in camera, if that's what we want to do.
Yeah. Yes. So, and I'm basing it on the Kenyan Constitution and then the South Korea situation where.
What does the Kenyan one say?
With respect to the president, not the Chief Justice.
Yeah, that's.
So it means that the process will be judicialized.
Yeah, because then you judicialize the whole impeachment process.
Yeah, but it is affecting somebody's rights.
Yeah, but it's affecting your rights. You don't have a right to be to the job.
A right
to the job.
I don't think so.
Not to the job, but the reasons for removal. If the reasons for removal are scandalous, there's nothing really.
But it's gone through a process.
Like you are saying, it is politicized. The whole thing has been politicized. No, the person is seen as belonging to the other side.
No, but if you follow the practice that the reform that he's proposing, so if you go through that process, you do a petition, you bypass the president, or the president just hands it over to a body that does that prima facie stuff, and then if it passes that test, then you constitute a tribunal, and the tribunal gives you the due process rights and everything, and they come to a decision. So basically, you have then turn the impeachment proceeding into just, the tribunal becomes just administrative tribunal, first level, like scratch.
Yes.
Then you don't like it, then you appeal to the Supreme Court.
You see, it is the politicization which is creating the problem for us. If there is nothing political, there are grounds, stated misbehavior, blah, blah, blah. That should end the matter. You must understand it yourself and just give way. But if you see a conspiracy, something has been concocted and put on you, just that they get you out of the way. And they say that's the end of the thing. You cannot say anything about it. Just take or leave.
So if the grounds are, say, incompetence, let's say incompetence, it's not violation of any law, right? It's incompetence, or maybe some ethical infraction, but not a violation of a law as such. And the tribunal believes that that conduct is unbecoming of justice or CJ, therefore, it's good enough grounds for us to take you out. And you appeal to the Supreme Court. What's the nature of that? What? It's a legal proceeding. They are going to argue matters of law or what? I mean, exactly what are they going to do at the Supreme Court? They are going to check whether you are incompetent or not incompetent. I mean, how is the Supreme Court going to make a whole lot of difference?
Incompetence, it will be very hard in the Supreme Court to say somebody is incompetent.
I just want to know the nature of the legal question that will raise for the Supreme Court, right?
You can see some of these things in some of the courts, but up to Supreme Court, people who are there should be, as you know, we should presume some knowledge of the law for them. Anyway, but we can look at it. Let me go through my issues and something that the Judicial Council's enlarged composition rather should bring in more of the Ghana Bar Association people, because they play a vital role in what is happening. They practice in the courts. They do recommendation. They know the judges. People have been recommended who have risen to very high. And because we know them, we know ourselves at the bar. We know ourselves at the bar. So you can easily recommend somebody from the bar to the bench and he will perform. You know, and we can block some who we know are not fit and proper persons to go up. So rather, one would have thought that we bring in more people. You see, you are promoted from circuit court to the high court without much experience. There are a lot of things you haven't done before. Judicial review applications. They don't bring them to you. Contempt applications, they don't bring them to you. There are a whole lot of things that you don't do. And if you don't stay there for some time before you are promoted, you come and be writing things, you know, saying things that you don't even know. So people even think that we should raise the threshold. How many years should one, you know, be at the bar before you can become a high court, court of appeal, and Supreme Court? And all come to play when you look at the lawyers who practice before them. And they will tell you, this person, he doesn't understand the law.
The Judicial Council, I think the number is what? 18 or 19? The bar gets to choose.
I think there are two.
There are two representatives, right? But practically, except for the last four, who may not be lawyers, everybody is pretty much, and maybe the chief from the National House of Chiefs.
But those who practice, that's the argument. Those who do the practice before them can make proper recommendation or assessment of the people.
Standing.
No, the practice, those who do the practice there, have that kind of.
Please, can I make a quick comment about those who are yes, in fact, from my experience, they are very helpful to the non-lawyers. The non-lawyers, because normally they will bring a religious person, they will bring an engineer, they will bring those people they brought are well-seasoned people, and they help a lot. Like when we were building the court complex, and the judicial secretaries, the Chief Justice residence. At that time, those 4 members on the committee helped a lot. And there was an ambassador too, so he also brought his experience. So those nominees over the years rather aided the Judicial Council when it comes to matters of comments, architects, engineering, and they are well-seasoned people. So it depends upon those who are nominated by the Chief Justice, but those who have been coming so far, even from their names and their background, they were well-structured and seasoned and experienced gentlemen. As for me, when I left before a lady came, gentlemen, because I met Beho, and when we were doing that tiger eye cases. In fact, when it comes to cross-examination, it's the lay people who rather take over the cross-examination with the judges and lawyers, because they were scandalized. Whereas we who are lawyers and judges, we rather keep quiet, and they took over. And then we had Asante, Dr. Nana, he helped represent the National House of Chiefs. And he stayed there for a long time, and he was a great assistance. Now, I don't know the composition, at least for one of my archbishops had been there, and they also say he was very good. A past soldier man, but Archbishop of Kumasi, the Bishop of Kumasi and Archbishop of the province, he too was very good and very helpful. So sometimes when we go to the meeting and even we want to put our problem, they will tell, oh, you keep quiet, we'll do it for you. Like, so they were very helpful. So I think we should have some non-lawyers on it, experienced and respectable non-lawyers on it. So those that, even some were recommending that they should bring someone from prison service, since they deal with those we convict. Then we say we are not on their council. So why should they come on our council? So we said those who we are not on their council, we should rather remove them. Because if we are on our council, yes. So why shouldn't we be on police council, armed forces councils? But you all want to come to the Judicial Council. If it's those people they want to remove, yes, but not the non-lawyers.
Yeah, but the non-lawyers, you see, who makes the appointments?
The president. Yes.
And that is where it becomes politicized.
Oh, it doesn't. Those people who came were very men of integrity.
I
We were lucky.
Unless currently.
We were lucky.
Currently, I hear to be Kwache and somebody has been brought.
Okay.
Highly political.
But Tokubi Kwache has a sense.
So we can look at that, those people who come, if they are being planned. Again, this issue of 2/3 supermajority, you say when there's a gridlock, what happens? I don't think I got an answer.
That was interesting. I think somebody has also made a similar point in one of the sessions we had, that the supermajority compels you to do pre-approval consultations and other things, because you know that if you send a candidate that is not acceptable to the other side, they will block it, right? So because the minority can veto the nomination, you have an incentive to deal with them before the candidate is brought. I mean, of course, it's a good response, but it is basically depending purely on chance that actually that happens. What is usually a good practice if you are going to require supermajority is also to anticipate a deadlock and to provide for a fallback where the deadlock happens. So otherwise, a vacancy can remain there forever and you can't fill it. You know, so it's best to have a deadlock provision in those instances.
But Honorable, in that case, what would you recommend? If you have a deadlock, you haven't thought of it.
No, it's a very interesting, I mean, the deadlock provisions that I have seen operate like a poison pill, right? So basically, you put something there that forces the decision makers, the two-thirds, those who are going to do the supermajority, it forces them to actually come to a consensus. Because if they fail to reach a consensus, the fallback option is worse for both of them. So you create a fallback option that neither side likes. Right? So if you say, for example, if we are unable to meet the 60% after two or three tries, the speaker and the president would decide. Then you realize that, okay, neither one of us would like the speaker and the president to decide. So it will force you to come to some consensus around the candidate. So usually that's how the supermajority rules work. The fallback option is worse for you, both of you who must decide, than you deciding. So it operates a very interesting, way of doing it, but it's not common to our practice. We don't do it that way. Yes.
Prof, I've got a question for Mr. PhD2, Professor PhD2. Sorry, I'm Agatha Roxton, an academia and also a lawyer. I don't know whether you've got any recommendation for us in terms of, at the moment, we kind of pit the EC towards the Supreme Court or the Judiciary. Do you have any, like we put the EC Commission, like the Electoral Commission,
Court of Appeal.
we kind of, yes, but they use Court of Appeal as well as Supreme Court. So there's this whole noise about...
It's High Court of Appeal.
It should be, yes, that's what they're supposed to do at Court of Appeal. But there's been a lot of noise at the moment in terms of if the EC chair was removed, then why are we... So can we try and decouple or try and educate the public that the judiciary is a whole separate organ of government and the EC, just like the legislature and the executive? Do you have any recommendations in terms of that for the public or for the country or for the executive?
So basically separating, making 146 unique to the judiciary and creating a different process for the other independent constitutional
in as much as, yes, exactly. In as much as we always say the judiciary is independent, we kind of also need to establish that, yes, they are independent, but they are also a whole separate organ of one of the three organs if we are practicing the separation of power. So that is what I wanted to say. And in terms of earlier on what my academic colleague said, Prof. Atupari, yes. It's very important for us to, in terms of the appointment of the judiciary. So I've submitted, and this for the executive, I submitted a thesis that I wrote on the independence of the UK judiciary. And it's very important for us to establish this because when the Honorable MP came in earlier on, he also raised the issue of how the UK system is done or the English court system is done. And I did a research on that, and I know for certain that when they are recruiting, they have created a whole judicial appointments commission as part of their Constitutional Reform Act of 2005. And therefore, when they are recruiting the judges, they even incorporate different departments, government departments, in the recruitment process. So for the English courts, for instance, they use the MOJ as well as the Judicial Appointments Commission. And the basics for this is, for them to, or the rationale behind this is, you cannot bribe more than one department, isn't it? So it's difficult when there are several departments involved in the recruitment of judges. It's difficult for somebody to try and get their way through several. How many of how many people can you pay within
If you are Elon Musk, you can pay everybody. It depends on how deep your pocket is.
I don't think Ghana we have that much.
Oh, we do.
So, but yeah, I thought this is a good practice as well for us to take into
So
consideration.
MOJ is what? Ministry of Justice.
Justice. So they involve MOJ.
Yeah.
It's in my thesis paper
Sure.
that I wrote, and I've submitted it online. Oh, it's only my thesis paper, 48 pages.
So
There is. So there's an abstract. So you will read, when you read it, you see there's a whole abstract with it, and then there's a... No, there's an abstract that gives you a whole idea in terms of that.
About the Ministry of Justice, I'm happy
very
you mentioned
important.
it because at lunch we were discussing. So we do all these things on the judiciary side, right? But then we know that the judiciary is only like the last end of a chain. It's the retail end of a whole production line that starts somewhere. You know, it goes through production, wholesale, the police, attorney general, they are all processing and then they end up in the judiciary. If you do all these reforms there, but you don't touch any one of those other parts of the chain, police, attorney general, Ministry of Justice, and which is part of it, can we achieve the kinds of reforms we're looking at without looking at these other parts of the chain? One thing I liked about Samson's presentation yesterday is that he was looking at a very discrete area of the fundamental human rights, but it was very closely connected with court practice, right? And looked at a particular situation, a particular practice from law enforcement that had ramifications, along the line, the value chain, and what are the kinds of reforms that may be needed? It doesn't have to be constitutional, but what are the kinds of reforms that we could also propose along that same line to make all this, what we're talking about here, at the last end of chain, effective? Because if you do all these things and the practice doesn't change with law enforcement, the AG practice doesn't change with AG, and Ministry of Justice takes no interest. So, for example, Ministry of Justice, what is its role in, for example, the administration of justice in the lower courts? Why can't the Ministry of Justice be playing a more important role at that level?
And let's not forget that the police are also involved at the lower courts, because at the lower courts, criminal cases is the police, prosecutors that deal with cases for attorney general. So again, they are interlinked, and therefore you cannot take one out or just try and make, it's very important.
Definitely, yes. It's a very important part, which I thought I should also mention. And I recall about 5 years or so ago, I did a project for USAID, and it was called a case tracking system, whereby we designed a software that is supposed to track cases, criminal cases, from the time of inception at a police station up to the time the person, if convicted, goes to prison. So that at every level or at every stage that the case is, you can view it on the system and see how the case is moving. And at the end of the day, you realize that you have to involve the police, the Attorney General's office, the judiciary, the prisons, yes. And so at the end of the day, if, for example, the person is put on remand, it is the prisons, the person has to go to prison. If it's time to go to court, it will send a notification to the police to go and pick the person and take him to court, and to register in the judiciary system that the person is in court and that he has been, the remand has been extended, or, So they are definitely all part of it. And I think when my lady said they don't want the prison service on their board, I said, maybe we should reconsider that, because they definitely may be useful to put the prison service on such a board. Yeah. And the point about the police and attorney generals, I think that's also very important. And if we can find a way to decouple their functions, the police acting as investigators and acting as prosecutors, it creates conflicts and it compromises the justice delivery system in the criminal sector. So if we can...
Comment that we not let police people prosecute.
Prosecute, yes. They will get money, or they should find money and do it.
Right. Thank you, Mr. Chairman. Professor Chairman, sorry. Now, in the discussion on the subject of judiciary, I think the important part of that is legal education. Because lawyers and justices are products of a certain environment for legal training and the regulation of legal practice in this country. There are two issues I want to raise on this. The first issue is that the institution that regulates and provides legal training is the General Legal Council. Now, so that institution also has a department, the disciplinary department of the General Legal Council. So let me tackle the first one. Now, when the law school was established somewhere in 1960, 59, yeah, so a year before. When it was established in 1960, it has remained the same structure, the same mode of training, the same space, because of pressures of populations and because of pressures brought on by a certain proliferation of law faculties in the country and elsewhere. Even this is my 16th year of legal practice, but when I went to law faculty, it was only the University of Ghana that provided legal training. Now we can count about 10 or more, or 15. Some are private, some are, and almost all the public institutions now have law faculties. UDS alone, that is now split into multi-campuses in Wa and Tamale. Each of them have a law faculty, and the other ones are striving to have law faculties. The private institutions have provided legal education. In fact, most of the law faculties in Ghana to here are imported law faculties. Imported in the sense that you have institutions in the UK that are leveraging on the demand for legal education, and they have satellite campuses in Accra here and elsewhere, Sunyani and all of that. So the critical question that arises first is the consistency and the quality that you can find across board. That there's a certain regulatory practice or certain supervision, not just that we have given them the license or the certification to provide legal education, but these institutions and the quality of education that they provide for lawyers, that you can find a minimum standard, whether you're having it at KNUST or you're having it at GIMPA or elsewhere in the country, because they meet certain minimum criteria. I find that that is lacking. There is the second question of, and that's the LLB level, that if you look at the law that pertains to access to professional legal training, the requirement is that you should have an LLB. Now, so in recent times, because I was teaching at the GIMPA School of Law, I was teaching LLB students for about 4 years. And most of my, very talented students finished the LLB and they couldn't access professional legal training for factors that I cannot enumerate here. So that is a problem. There's a huge backlog as to what happens to these people. If the law still is the case that only the General Legal Council can provide professional training for lawyers. So there are two schools of thought. And I belong to the school of thought that says that let us expand, okay? I'm of the view that, this is a proposal, that let's expand access to professional training, and that we could have, let's say, a single exam that will be conducted irrespective of where you receive this professional training. We should have this discussion as well, because garbage in, garbage out. If we talk about quality of justice delivery, part of where we can trace this problem to is the kind of quality of education that is that's provided at the institutions. So there's that dilemma. I would like your insights. Professor Atupare is not here, but this question is thrown to everyone here. I think it's an important discussion that we should incorporate into the judiciary, the discussion of the judiciary, because the major players in the judiciary are lawyers. And
where
lawyers,
would you put this? Would you put it in fundamental human rights as a right of access to justice? I mean, where exactly would you put it in the Constitution? So assuming that we could formulate something like that, would it come in the form of a right of access to exactly how would you put it? I mean, okay, Jay, you have...
I'm not sure it fits directly under the judiciary. In some civil law jurisdictions, they have training for magistrates and other judicial officers. So in that case, you can fit in there. But in the common law jurisdiction where we just train lawyers, and when you are trained as a lawyer, there's the implication that you can practice on the bench. And so you need some minimal level of training to be able to sit on the bench. So I'm not sure if it fits directly in here. Probably, I'll put it under access to justice.
I mean, there are, I remember Azar brought a case, right? He mentioned that he had brought a case to demonopolize Makola, which the court, I don't know what happened. Now, very recently in Kenya, the Supreme Court of Kenya has ruled that, I think it's the High Court, that the monopoly, the Makola-like monopoly in Kenya is unconstitutional.
Yes.
So, yeah. So now there is no one law school, training school has that monopoly in Kenya.
Yeah.
But a similar lawsuit here failed. But there is under Article 25(1) educational rights. I think Kweku Hazard was coming out. Every person shall have the right at his own expense to establish and maintain a private school or schools at all levels and of such categories and in accordance with such conditions as may be provided by law. I don't know if that is where he was trying to come under.
But it fits in there. I think
it could be there, right?
Yeah.
I think he tried to use this to demonopolize Makola, but it didn't work. But I'm sure a similar lawsuit in Kenya, even similar provision would have worked in Kenya. So maybe that's where we put it. It will be hard to find a place under the judiciary to put it. But I agree with you that these are some of the questions that we should be looking at in terms of how to make this whole reform effective. For example, legal aid. What do we do about legal aid?
Exactly, yes.
Right? You don't have legal aid.
This problem that he has raised has been, discussed severally. That if the private faculties can go ahead and do the professional training and they all sit one exam, that should be okay. But the problem is that the accreditations that are given to them are not properly done, to the extent that they don't seem to have what it takes to train the professionals. They do, according to the Judicial Council, or General Legal Council, when they did a run, a check on the facilities, they realized that they didn't have them. Apart from lecturers, the books were just not even available for training. So they are not adverse to it. If only they can equip themselves to the standard of the Ghana Law School. If they can equip themselves, they could be permitted to do it. But we don't know how some of them, and I hear sometimes we have one lecturer running between faculties. He will teach here, he run and go and teach there, and one person running around. So I don't know whether he's also
wait for that to correct, right? I mean, in a way, the market can correct that, right? So if you have a barrier, the barrier is you have to pass a certain exam anyway, whether you go to a school with libraries or you don't go to a school with libraries. The regulator has imposed an exam at the end of all the process, without which you cannot become a lawyer. So if indeed there's that barrier there, over time, if you go to schools without libraries, you will continue to fail. Your products will continue to fail. They won't get into the bar, and then your school will collapse.
Well,
I mean, there's a way in which sometimes, markets can correct for these kinds of things, because if you impose it as a pre-requirement that you must have all the schools to this level, then nobody, Makola will remain the only one for a long time. And even Makola, I'm not sure that Makola has. What library do they have?
They do. It's better than the rest. That's what they are saying.
Makola
is better than the rest. The rest, they are saying, they don't come up to standard.
Yeah, for example, University of Ghana has more libraries.
The lack of integrity, the lack of integrity in the system, people will pass through.
Everybody
people will pass through. There's only one exam, but people will pass through.
Yeah, but that cannot be a reason for not.
That is Africa for you. All kinds of people will come and mess up. Today that we are passing, calling 1,000 to the back.
If it is the General Legal Counsel that is saying that these other schools do not have the right facilities, aren't they conflicted? Because members of the Makola itself are part of the General Legal Counsel. So they are sitting in judgment of potential competitors. They should be recusing themselves from the discussion.
Exactly.
They should not be taking part in it.
By law, necessity.
So that shows you that even the General Legal Counsel and Makola, they have major structural flaws. And these are the people who are determining ethics of lawyers.
I don't think they intend to monopolize.
Oh, no.
Because otherwise they would not have accredited all the other law faculties.
AG, let me, if you excuse the chairman, excuse me to bring a second issue regarding the General Legal Counsel and the important role that they play, former EC Chair Charlotte just mentioned it briefly, in terms of disciplinary proceedings that they adjudicate upon. I'm constrained to very.
Are you a defendant before the General Legal?
I have served on the board of legal education.
Precisely.
General Legal Counsel, Judiciary. I have a lot of it. You say it.
Right.
Say, feel free.
Now,
I think
maybe
you are more qualified.
Maybe what you are going to say, I even know about it. Just go ahead.
No, I'm not going to. Okay, so the GLC, I think that the problems or the issues that exist with the GLC, the slightest
that are coming out, if you don't crack the whip.
And all of those things, it's not part of constitutional. It's not part of constitutional review as such. But I think that the culture in the judicial system and the legal profession generally does not promote justice.
Yes.
If you have people who need to stand up and defend their clients, and they themselves are cowed into submission, sometimes treated like they are children. If you go to court, and you see some of the ways the lawyers are spoken to, your clients will not even have confidence in you. So I think there's a whole culture that needs to change.
But after 44 years, I haven't had any difficulty with that.
But you are a senior lawyer. When you go, they give you privileges.
Even with the issue of legal education with the General Legal Counsel, for the practice of these entrance exams we're talking about. You see somebody who is a practitioner, he's been written to set questions. Remember, these are students who are coming from academic faculties, not professional faculties. There's a distinction. Professional faculties, are different, and which is, we have it in town. Makola is a professional faculty. Academic faculties are in the universities, and they are writing academic entrance exams into the professional faculties. Then you have a professional setting questions for an academic. So you have lawyer setting questions. Then when it comes to the marking, you have a judge marking. So the relationship between the judge and the practitioner is not there, and over the student. So the judge says, when we look at this script, it's supposed to be like this. And don't forget, at the conference, the conference of examiners, the examiners are entitled to even change the marking scheme. So you get there, there's a marking scheme. The judge says, I don't understand, I'm part of this exercise. These cases, we're going to change them. But these are the cases you have taught your students. Constitutional law. And the cases are changed to 1960 cases, which the judge understands. So anybody who did not mention those cases is going to fail. And he is being made the lead of that team. So you are sitting there, not just, you are sitting there as a passive passenger. This is the General Legal Counsel with legal education. Aside the fact that we have this kind of babies. People go to teach 2 weeks, and then they will leave what they've been teaching to a junior who struggled to pass his exams at the School of Law, and he's the one who is going to teach. And I'll tell you my own experience. I have a lecturer who could not distinguish between ownership and possession. And the person taught throughout. They said, we can't do anything. That's what the person told us. There's nothing you can do. Possession and ownership, the person cannot do. General Legal Counsel on legal education is not able to supervise this. So all these quality things we are talking about is a kind of an integrated web which must be examined thoroughly. And I'm sure it cannot be just a subject of constitutional review, but there must be discipline through some kind of acts, legislation. Who is the faculty? Who must be appointed as a faculty? How did you get to teach at Makola? Is it because your senior is teaching, therefore you follow, and over time you are made a lecturer? Or you applied independently and you go through the process before you get there? So we have all kinds of problems. It's just not just that entity. It is what we do from that entity that is going to define the quality that we all are entitled to as a matter of legal education in the country. Otherwise, we may pretend to have that body, and then people will be pretending to be doing what they like in town, and we'll continue to have these problems that we have.
My concern is about the power of the president to appoint lawyers direct to the Supreme Court. Professor Atuguba did the research, and one of the findings is that those who were directly appointed to the Supreme Court always ruled in favor of the government or the president that appoints them. So my suggestion is that we should be able to... Yeah, that's one of the findings.
Actually, at the academic forum where he presented it, he was lambasted openly. Yeah. They were threatening him with contempt and things.
So I don't know whether there can be any provision in the Constitution that nobody or the president shouldn't have power to appoint people direct to the Supreme Court. Before you can be appointed as Supreme Court judge, you should have served at least 5 years or a number of years on the Court of Appeal. Yes. So that you don't get appointed straight. Yeah, yes.
Well, but there are different...
some of these career judges have been there for so many years. Nobody is thinking about them.
Yeah, but there are different routes to... There are different routes to the
Supreme Court. I think we should...
You have to be a judge before you get to the Supreme Court. I mean, most of the judges, so for example, Supreme Court does constitutional law. The judiciary, from below up to the, until you get to the Supreme Court, you are almost doing no constitutional law at all, right? So you can get a constitutional scholar from the faculty who knows, of course, far more constitutional law than all of the, Court of Appeal, because they never do the
Can be appointed to Court of Appeal instead of straight to the Supreme Court?
No, but I'm saying that the Supreme Court has original jurisdiction in all constitutional cases, for example, right? So the High Court judge can have, because they do human rights cases, on the fundamental human rights side, they have some. But the judiciary, if you're going to say that, if we had a judiciary where from below you have general jurisdiction over everything, then you do constitutional cases, but if you have to wait in your career to get to the Supreme Court before you do constitutional cases, then saying that we should appoint only judges there means that we're going to have actually a Supreme Court that knows very little constitutional law, because that is not what the judicial career trains you to be. So appointing from the bar, there's nothing wrong with it. I mean, in fact, practicing lawyers actually sometimes are the ones who write the briefs for the judges to even know where the law is, right? I mean, if very good advocates, judges actually really make the judges. If you have a good advocate before you who's written a well-researched brief, that is actually the judge's best friend, because they will teach you the law instantly. You don't have legal researchers here a lot. Some of these law firms spend their whole time doing this. So they are a benefit. And so that training counts for something. You can't say you shouldn't pick a private lawyer to the bench. And you can't say you shouldn't pick an academic. I mean, somebody who has taught, including constitutional law and everything, and probably has written in the subject, to say that you can't just pick them to the bench. Some of our best jurists have been picked directly from outside the bench onto the court. I mean, Modibo Okran was, before he passed, he was doing some really great constitutional law. Professor Databan recently. So I don't think that one will fly at all.
Thank you, Prof. Just a follow-up to what he said and then your response. I believe strongly that we should be able to appoint people directly from practice or academia to the Supreme Court. But in the past few months, my experience has been that there is also a challenge with that. And that might be the reason why we may have to look at the divisions at the Supreme Court. Because I've seen some of the academics end up at the Supreme Court, and when there are cases on criminal matters, cases on proper civil procedure, you observe
who do work. And of late, I'm told they are doing legal assistance, research assistance. I don't know whether it's still working. Since I left serious practice, I don't know. But they also got attached to them, legal assistance. In fact, in the US, that's what they do a lot. A lot of legal assistants who do the deviling and the research for them. You cannot know everything. So that should also be encouraged, but I don't know. This is only, as far as I know, at the Supreme Court. I don't know what happens at the High Court and the Court of Appeal, whether they also have assistance.
Yeah, I don't know why it's so little used here. I mean, every judge on the U.S. Supreme Court, I think, has 4 law clerks from the top law schools. The Chief Justice probably has about 6, right? And these are, qualified lawyers, usually just, have passed the bar. They write the drafts of a lot of the memos. But I don't understand why we don't use them as much here. I don't know.
Maybe we can't pay them.
It's cheap. Actually, the cheapest labor you can find. I mean, the cheapest labor you can find are law clerks, and maybe not the one you're talking about. It's not a career. The U.S. system, you leave law school, maybe 1 year of practice in a law firm, or even before you go to a law firm, you serve as a law clerk to a judge. And then after the law clerkship, a year or 2, that's when you go into private practice. So they just pick the best and brightest students, use them, and then they go on to their career. If you want to make it a career, that's different. Some places use career law clerks, but that's not what I'm talking about. There are so many lawyers being churned out by the faculties. You can have an arrangement with them. Give me your best students every year in this area. They will come and become law clerks to a judge. And the judge is still the one who controls, but they do research, they write memos, and because you have more than one, you can set all three of them to go and do a piece of research for you, compare, and then you figure out which ones are best for you. There are ways in which these courts that are efficient in Kenya and all the other places we are talking about, they use some of these things. They use law clerks, they use technology, we are just resisting change. They were just resisting change and burdening our judges and then using that as an excuse to make 20 judges and more, and things are slowing down,
In a room full of lawyers and things, and that's why I've been very quiet the whole day because monkeys play by sizes. I just wanted to find out, quite a number of very useful suggestions have come up. But I think it would help if we categorize them, so to speak, in terms of those that can find expression in the Constitution. Either that we are amending some portions or we are introducing new clauses, etc. And others that can be dealt with through legislation, through other distance, so that then we focus a bit more on the ones that, can be addressed through the Constitution. And perhaps maybe in the footnotes to our report or maybe a separate one, we highlight some of these points that in order for the constitutional amendments to be effective, maybe some complementary legislation, etc., needs to come up. So that's my suggestion regarding this. Thank you.
So any other interesting things for constitutional reform or our attention?
Prof, I have just point of interest, because as a traditional ruler, I know that the Courts Acts recognize judicial committees as courts for resolution of dispute. Yes, judicial committees of the regional House of Chiefs and the National House of Chiefs. And recently, the face of chieftaincy brings in security issues, national security issues. If you take Boko as an example. And then
one lawyer serving different houses of chiefs because yes.
And
then when they lose a case, then they go and raise objection that he was asked to be at Bronga Afo, but he came to Western Region.
Their salaries are not being
When I was Attorney General, I think I realized for the first time that it was his job to see to the recruitment of some of these lawyers to the regional houses and the rest.
Yeah, because you are involved in it. It says on the recommendation of the
Attorney General. Yeah. So we realized that we couldn't attract lawyers to go and work there.
Because you were not paying well. Now
that is
their salaries are not pegged to the judicial service. So
it's better now.
People are available.
The country is broke.
You mean it's better now?
Oh, yes.
Okay.
Yes,
that's right.
If you take the regional House of Chiefs, the reason why I'm recommending the increment from 5 to 10 is because the regional House of Chiefs lawyer receives the salary of a circuit court judge. So he thinks that that is not enough. That is aside, apart from the quality that we are talking about. So if you put it at 10, salary scale, he will be a high court justice. So that would be enough for some people to run and serve. National House of Chiefs, if it's 12, that's Court of Appeal. National House of Chiefs.
But this practice of it's almost like the whole Constitution is written for salaries.
The lower courts especially. Now the circuit court is hearing cases with monetary jurisdiction around 2 million Ghana cedis or so. So that means a lot of cases will end up being with the circuit court. Now, if we do not address this situation where a lot of these cases are going before the circuit courts, And we have a system where a judge in the higher courts or even a chief justice can simply place a phone call and say, look, you have to do this. And if the judge does not do it, the judge ends up being transferred to a place that, in the mind of whoever is transferring that young judge or that judge at the lower bench, is to serve as a form of punishment to the person and deterrence to other people who are at the lower bench. Then we end up corrupting the judiciary even at the base, even before it gets up there. So I'm thinking the administrative authority of the Chief Justice, for instance, we should find a way to control it, especially when it comes to the transfer of judges. And it's an open secret. Even at the higher levels, the Superior Court, we still see judges who, for one decision or the other, end up being transferred without any real reason. So I think as we are addressing the power of the Chief Justice to empanel judges at the Supreme Court, we may also look at this to create some individual independence for judges at the lower level when it comes to exercising their judicial authority. Thank you.
Any more issues, or are we close to the end of the day, which would be not a bad idea?
Yeah. Raising the year standing for appointments. The years standing of
judicial committees.
Yeah, for High Court, Court of Appeal, and the rest. Some are suggesting High Court, I think now is around 10, to raise it to about 12 or even 15. And Court of Appeal to go up with Supreme Court even 20 and above. I don't know whether you have given thought to it, Prof.
Yes, I think that issue has come up, and the view is that we should raise the ages, the years. Yes, because of course we know that in practice it doesn't really work like that. That you are 10 years, that you go to the High Court automatically. And that is also a way to justify raising the years, because at the end of the day, somebody will say, "Oh, I'm 15 years. I could have been at the Supreme Court," but that also sometimes can be taken advantage of by a president who wants to appoint people that he wants to go to the Supreme Court based on the lower number of years. Yes, so it could be a way of checking that as well.
Prof. But why the proposal was that the years in the bar really is not the issue, right? But the experience that you have acquired since becoming a lawyer.
Yes.
So if we were to move in the direction of counting experience rather than just years on the bar, then why would we need to make this, why would we need to add additional years on the bar? Because if you got your bar license and you just sat home or went to use it to do galamsey, and 15 years later, as a pocket lawyer, you show up and they say, well, you had your license for 15 years. Now that's different from someone who got their license and hit the ground running and has been practicing since then. So maybe the real issue here is not, you don't need to raise the number of years, you just need to tie it to experience, as opposed to just 10 years at the bar or 5 years at the bar, right? Otherwise, then you would also be disadvantaging bright, industrious, resourceful young people who have, notwithstanding their age or lack of big seniority in the bar, have become really very good at what they do. So I don't see that I think I find more merit in the experience, criterion than in the number of years.
That is where they
criteria.
are going. It's not necessarily the years, but the practice. In terms of experience, we should be looking more at practitioners. Like what we have said,
Years
the guy
of
has a
demonstrated
degree,
practice,
he has a degree, but he's doing galamsey. Say after 15 years he comes. So that we should veer towards getting practitioners, people who are using
have
the
used
law.
the law license since they graduated, whether as practitioners from the Attorney General side or the private practice or the bench or academia. I mean, I am more persuaded by that. There is one other issue that has not been raised, and I want you guys to reflect on it, that the difference in retiring age between High Court judges and the Appellate and Supreme Court. Can anybody tell me the justification for it? Why High Court judges must retire at 65, but the Appellate Court beyond that must retire at 70? The reason why I think that is also significant, if we are talking about judicial independence, is that it could also be used to reward and punish favorites, right? If we don't like you, we will let you retire at 65. And if we want to bend you, we can, if you do the right thing, you'll get 5 more years, we'll promote you to the Court of Appeal. So, these are things that on the face of, on their surface might look innocuous, but actually can easily be manipulated to influence judicial decision making, especially when you are a High Court judge, you are getting close to 65. Nobody is telling you anything. These cases are coming to you that are really very important. How are you going to decide them? Right? Because if you make the wrong move, you retire. If you make the right move, you get 5 more years. But I don't know the logic originally why one is 65 and the other is 70.
Prof,
it's interesting.
I beg to add something before that is addressed, and it's on the appointment in terms of experience and the years. What about, let's say you are called to the English bar and you work there for 20 years before coming home, that is joining Ghana, and then you arrived, you were able to go through the post-call. In terms of experience, will that be counted? Because I guess it's basically about call to the Ghanaian bar, and that means that if you want to go to the Supreme Court, you have to wait for 15 years. So you would have had 35 years of work.
Is that how it's been interpreted? That it
I am thinking so that if you arrived and you get called to the bar, the Ghanaian bar, then your years will begin to count.
So
and
if
you want to go to
your years spent in Canada or UK
would not. So in terms of
I don't think so. I think it's just one of these job protection rackets in the system that is anti-competitive, right?
Prof, they will resist you. I think so. If you want to be nominated to the Supreme Court, you'll be resisted.
You are protecting mediocrity.
That is something that you might want to look into, because it is not clear whether your 20 years will count when we're dealing with years standing for your nomination or.
I don't know. We've appointed some people to the Supreme Court recently who spent lots of years outside Ghana.
They were called to the Ghanaian bar first. And they went for graduate studies and remained there.
So even while you are chilling there, it's just counting.
Exactly.
Oh, but it makes no sense.
It counts.
You guys can do whatever you want here. I don't know. The 65, 70.
I've not thought about it in the way you have expressed it, but I think it can be a basis for, as a way of promoting people who are compliant and are able to do the bidding of a particular person, or as a punishment. But I don't know the justification for that, and I don't think is necessary. To me, if it is 70 pegged for the judiciary, why should it cut across? And yeah, thank you.
But, Prof, we have the same thing at the university.
Sorry?
Yes, we have the same thing at the university. If you retire as a senior lecturer, you can go up to 65. If you're a professor or associate professor, you can go up to 70.
Oh, is that what it is?
Yeah.
Okay.
But they are following
I think it's a little bit different because no, because at that stage you are retired and you are looking at post-retirement contracts.
Contract, yes.
Yeah.
So it's an incentive to make sure you qualify to become
a professor. Yeah. And so that is a little bit different from the judiciary one.
Yeah.
Because the judiciary, you are still you are not retired.
That's right.
And then they say they are capping your age, retirement age at a different, depending on which court you are in.
I mean, maybe the research team can help us figure out exactly why the I've never seen it anywhere where there's justification for. It's not there. I have the committee report. It's not there. I mean, so yeah, why one is 65, why one is 70, and I don't know of other jurisdictions that have that kind of variation. No, it's the same for.
Prof, could it be that it's curious because the High Court forms part of the Superior Court's judicature. So if you were to categorize them as an institution, then they're part of it. So it's really discriminatory. But except that, if the thinking is that by the time you are the Court of Appeal and Supreme Court, you are a real rare resource, okay, that your experience, a number of years on the bench, is something we should not easily, we should retain more of your service to the nation as opposed to, I'm just thinking, I'm not seeing that.
No, but say you started the High Court at 50, right?
Yes.
You started High Court at 50, you put in 15 more years, you are 65.
That's 65.
The same logic, because of the maturity and the experience and wisdom you have gained, we should keep you by moving you to, why don't we say that? And then we dispense with you at 65, and then go and pick somebody else from someplace and put you on the High Court where you have 5 more years, right? So, I don't know why. I'm just wondering.
I'm just thinking perhaps it's financial because there are many more High Court judges than judges in the Court of Appeal.
It's the financial.
It could be financial.
Okay.
That may be the reason.
Financial, as in the payroll burden on the state.
Exactly, because there are many more High Court judges than Court of Appeal, the Supreme Court. So the state can afford to bear the cost at 75, at 70, but at 65. There are too many of them. So it's better you limit the number.
Oh, they just give them smaller pay. I mean, so.
No.
I mean,
you want them to be paid less than what they were receiving.
No, but your age, your pay should not be dependent on your age, right? We're talking about retiring age. And if you are a High Court judge at 70, you still will be earning less than a Court of Appeal judge at 70, right?
Yes.
So.
But it's the pool. If you look at the judges in the High Court, there are many more than the numbers we have.
But they are still retiring on their salary anyway, right? So you are retiring them at 65 on their salary. Maybe they could work 5 more years.
And get retire on a higher rate.
Oh, that's what.
Yes.
Yeah, but you don't have to keep them. No, I'm saying you could still keep them in the High Court until 70. Right? I mean, so keep them
at the same rate.
At the same age, retiring age, right? Of course, there's already a disparity built in between the judiciary as an institution and the rest of the public services. That I don't also understand. Why everybody else is 60 and the judges are up to 70, right? So, but we can put that aside for now. But this, for me, this disparity between High Court and the more senior benches is what
you have to look into that.
Yeah, because I'm looking at it from the point of view of just that being manipulated
Parity.
To give somebody 5 more years on the bench if they play ball.
Yeah.
And
they just tell you to decide appropriately. So.
Yeah.
What about the years difference in terms of standard? The years difference. 10 years I can be at the High Court. I cannot go to the Supreme Court. I have to wait for another 5 years. So I am thinking the years difference in terms of standing to go to the courts, my account of that. Though I agree with you that it's unfair, because these 3 courts are all courts at the Superior Court level. But if I have 10 years, I'll be there. That means I'll have more years to be on the bench. But a person who wants to join the bench at the Supreme Court level will have to wait for another 5 years, additional 5 years, before he gets there. So it looks like we are adding those years to you, which you could not have ended at the High Court level.
Yeah.
Yes, I agree with that.
Right.
Yeah. But the other thing I'm thinking, myself and my friend, is that it could be an incentive matter. What do you do to encourage me to go to the Supreme Court?
Unless we could say that maybe the High Court, the work is, the High Court judge being a single judge, right, is maybe more overworked, right? So by the time you hit 65, but that doesn't explain why your other colleagues who have also hit 65 are then given 5 more years to go and to be overworked again, right? So it's just, I think it doesn't solve. We're trying to, divine reasons why. Yeah. But I think for me, the curiosity is, I used to think that because you're a single judge, a trial judge, you do a whole lot more than an appellate, right? Appellate judges are just supposed to deal with questions of law and all of that, not review not retry the facts and all of that. So maybe somebody has built the record for you at the trial court level and all of that. So it's more tedious to do a trial than to do appellate adjudication. So maybe the load of work and the toll of the work is not as severe at the appellate level. Yeah. Of course, the judges there would disagree, right? Yeah. Because they say they are overworked, there's a lot of load of work. So I have tried to figure out these possible reasons, but I haven't even found a judge who has explained to me why that happens.
But there are just possibilities. Remember, some judges also refuse promotion to Court of Appeal. You are aware of that. They refuse promotion. They will not go to Court of Appeal.
Because they are tired.
They prefer to be there.
Oh, I see. Yeah. There's a lot of power there.
Sorry, I want to take you back to executive, what we did yesterday. The executive, not on judiciary, executive.
Anything else on the judiciary? If not,
Why are you taking us back?
We can entertain that one. Go ahead.
Okay. We all know what happened in Côte d'Ivoire when the opposition won the election and then the president refused to hand over to him. And then we also heard several times from the former president that will not hand over to Mahama and all this.
It will have influenced the framers of the Kenyan constitution to take the approach that I read out yesterday. Instead of vacating the office and getting a caretaker president, what the Kenyans do is that from the day of the election until the next president is sworn in, certain very specific powers are taken away from the president. So you cannot make certain appointments from that day, the day you cast your vote, up until the time a new president assumes office. That period is called a period of temporary incumbency. You are still the incumbent, but you are deprived of the power to make certain decisions. And I think that is probably less destabilizing than vacating the office and bringing a caretaker who may do a coup and decide not to leave. So it's a lot of different ways of dealing with this transition problem. Yesterday we spent a lot of time talking about transition and how we transition from one government, especially when the other party wins, one government to the other. And I think it's something that is real for us Africans, Ghanaians. So it's good that we are thinking about how we handle the transitions, because there can be periods of a lot of chaos and potential anarchy. But I think your solution, I've heard it before, but I haven't seen a country that has adopted it. I think the Kenyan way, and we don't have to, the Kenyans limit it to only certain appointments, right? You can't appoint many public officers, ministers, ambassadors, Superior Court judges. You can't do, and based on the Ghana experience, you could say you can't even make appointments to the security services or whatever during that period. So every country has their own peculiar experience with this problem. And I think the challenge of constitutional review is to find the solution that works best for your context and that answers the problem in your context. I think Ghana too probably, it would be worth our while to look at that, the Kenyan option, and maybe expand on or change the kinds of powers you may not exercise. In the Kenyan one too, you can't, for example, exercise the power of mercy. You can't pardon prisoners during that period when you're about to go out. And somebody, I think yesterday, was saying, oh, well, we should also include maybe you can't make certain transactions. Because for us, that is a problem during transition. People go and incur debt, last-minute contracts and last-minute awards of licenses and stuff like that. So maybe that's what we should look at. But the caretaker government idea is a radical one.
Let me just add that. Sorry.
If we were to adopt the Kenya format, what does the Kenya one say? Or we may have to expand it to include a limitation on the president's powers to commandeer the security agencies or security. Is the commander-in-chief and also head of the police and all of that. Perhaps we may have to find a way of curbing the use of those powers
during the transition period.
During the transition period.
Yeah, yeah.
I think yesterday we were struggling to identify roles for the Council of State. And I think this period of transition could be one of the areas where we can see
purposes, right? But if that's our challenge, have that same sensitivities around moving security services and stuff like that. But if in our situation that is a concern, So the young, the younger people in the audience for whom this constitution is being reviewed and rewritten, you are saying nothing. Mr. Yankson, they say you represent the youth, so say something. You're going to allow we bald hairs people to.
I was hoping to get away with simply saying I concur. I'm very interested in the discussion around the transition period and the limiting of the president's powers, but I'm wondering, would it not be more effective if we addressed the president's powers as related to the appointment of all of such people anyway, not just during transition, so that at that time he doesn't, even if he wanted to do something, he wouldn't have the power regardless. So, for example, if you take the IGP, and if we are concerned that in that 1 month the president could suddenly change the IGP, and we don't want him to have that power, why don't we simply make it so that the appointment of the IGP as a matter of principle has as little to do with the president as possible, so that in that period he couldn't do anything anyway if he wanted to? Or create a process that is so stringent that it can't be completed in a month, so that during that period the president does not have the ability to make such big changes when he's supposed to be, what's the term you used, interim incumbency, temporary incumbency.
No, I think a lot of the proposals that have been made on the executive go to the appointment powers of the president. So we've had a lengthy discussion here about many offices and how they should be appointed differently from the way they are appointed now. I haven't heard yet here specific proposals on, say, the security services and how to appoint them differently. But it is a very difficult area because at least as commander-in-chief and of an institution like the military, which follows a chain of command, it is very difficult to take the president's, that chain. I mean, the military is used to being organized that way. And so, of course, constitutional innovation is possible, but I haven't seen many cases where a president has been deprived of the power to change, especially the military. The internal police is different somewhat. Law enforcement, yes, some constitutions, the Kenyans have even tried it. In practice, it hasn't changed a whole lot, but they've tried to constrain the power of the president in terms of removing the IGP as more fixed tenure. It's, I think, one term, non-renewable. But, the president is still there doing the appointment. I think based on our experience, I think people are more inclined to think that, maybe the IGP must have a little bit more protection, more job security, both on the front end in terms of appointment and on the back end in terms of removal. But I haven't heard yet on the military side, and that may be a tricky one because of just the peculiar nature of the military institution. But you're right. If we sorted the problem out on the appointment side, our anxieties about what the president might do with the military or police during the transition would moderate significantly, right? Because we are concerned because the president gets to choose all these people, and our fear is that if we don't constrain his power during this period of temporary incumbency, he or she might use these agents of his to do certain things. So I think based on our experience, yes, we're quite entitled to have that anxiety and to think about how we might use it. So maybe the appointment process can have a curative effect or a downstream effect on that kind of stuff.
There is also the other side of the coin, though, the dissenting view, if you will, that in that period, if the president does have the power to make some important changes, it could inure to the benefit of the state. We all have the example of that last-minute appointment of Daniel Domelevu to point to. He did turn out to be quite an asset to Ghana. And he was appointed at the very last minute in that interim period. So you might argue that it's the kind of power that a good president could do good things with.
I think you are right, but it's also probably the kind of power that a bad president could use to cause
terrible things
plenty of damage. So I think the risk is greater that it would be used to either complicate the life of the incumbent, incumbent, and put obstacles in their way. After all, if you had all those good ideas and you could use your power for all these beneficent purposes, why now? Why didn't you use it all the 4 or 5 years you were in power? And now in the twilight of your government, all of a sudden you have turned angelic and you want to save the country and all of that. So I think it's the other risk. The downside risk is much greater than the upside, that you might use it for good. And maybe that's why the Kenyans, for example, are doing it this way. But I think it was something that had not come, having seen all the submissions, but until Renato Dazi raised it, put it front and center yesterday, it's not something that I had thought about. It's not something that many people had considered, even though we knew that the Transition Act must be looked at, right? I mean, that point had been made that we need to look at the Transition Act and see what it is. But it was mostly in terms of appointments to state-owned enterprises, how you remove people, how you do those things. But I think he put it in a context that was broader for all of us to see the risk of not dealing with that particular period in our system, and it was a very useful intervention yesterday. So, well, since we're last here last Friday, you come every Friday or something. But we've eaten already, you know. But you were here for the political parties conversation. Oh, they are here to report. Oh, okay. I've been informed about your presence and the reason for it. Yeah, because I've been wondering why you've been absent all week, and then all of a sudden you show up, you storm into the place. But I understand your mission. But we have had some really interesting conversations this week, and I think we would have benefited from your insights as well, especially on the legislature and the executive, including on this matter of the transition. And I know you probably have some opinion and other things to share on that. But it's been a very good, fruitful week, just as last week was. We will bring the discussion to a close.
Oh, Prof. You wanted to come to me on the issue of the young people not saying anything. People. Yes. Yeah. Thank you. Prof, I was also very worried when, especially on the discussion of the judiciary, where it became on almost every issue, let's go up the years ladder, let's go up the ladder in terms of the years where anybody gets to do anything. And I think that there's a strain of anti-youth in the way we go about things in this country that we should try and cure and stem with this particular constitutional review exercise. There's a study that was published in the political science department, basically traced, for example, the average age in the government of the First Republic was 35 years. By the end of the Kufuor administration, the average age was 57 years. And yet, ask every Ghanaian what was the golden age of governance in this era. Chances are that they'll tell you it was the First Republic, where we had...
Because they were too young to know.
You can say that, but there's something to be said about the fact that that was a more ebullient era because we had people who dared to think and dream and do new and big things. This country, like you pointed out, it does not belong to old people. Look at the demographic of Ghana. It leans towards young people. We should be developing a constitution that will promote young people. If the worry is that, for example, we don't have very good lawyers, then we must fix legal education. If you are not good at 10 years, you won't be good at 12. If you are not good at 15, you won't be good at 20. Exactly. So let's fix the issues where they are instead of always just trying to jack up the age limits and keep out young people. That's my submission. Thank you.
Good point. I think yesterday was a suggestion that young people should not be on the Council of State.
The President of the United States, 35-year-old can be President of the United States, $18 trillion economy. They can entrust it to a 35-year-old. You know, I was in class, I'm there, and my dean said, 41 years, you are too young to be Speaker of Parliament of Ghana. I was scandalized by that. When Macron was 35 years and was running France at that time.
You know, I agree. I think part of the problem, you know, and it's true. The truth also about those countries is that whoever is president is backstopped by a very strong bureaucracy or public service or civil service, however you call it. So they don't depend too much on the president to do everything. You know, these countries don't depend on the president to be the philosopher king who does everything, does all the thinking, does all the heavy lifting. There's a very strong bureaucracy and technocracy that governs the country regardless of who is president. You know, when you have a country like we have, where we have essentially destroyed the public administration, we have weakened it, and everything rests on the shoulders of one person, the president. That is where all these anxieties come in, you know. So really, I mean, you're correct, you know, but whether or not we elect a young, old, middle-aged person, the real challenge is just the sheer volume and load of work and expectation we place on the shoulders of that person, and the fact that we have weakened every other institution in the country really creates a huge problem. And that is why some people think, if you are too young, it's too risky, we can't do. But, you know, Macron can come, yes, he can be a visionary and he can do things, you know, UK, but the civil service works. It's there, it's stable, you know, and it's seasoned. You know, so I think all these things must be solved at the same time. What I'm saying is that you push one thing here, you have to push the other thing here. We should deal with all of these problems about the public administration not working, taken over by politicians, overly weaponized by politics. And when you do that, then it becomes, people are like, you can't do the work. You know, I don't believe that. You know, I think you are right. If you can't write well at 10 years in the bar, you can't write well at 12. In fact, you'll probably be worse at 15. You know, so I agree, you know, but we need to build all these other institutions so that we don't exclude young people because we think this job is too weighty on their shoulders. You know, it shouldn't be on one man's shoulders or one woman's shoulders. So, you know. Yeah, I think if we don't have any questions, then we will do the ceremony with our brethren. You are accompanied by a sister too? Oh, okay. With our brothers from IDEG have been with us from the beginning, and they've done some really solid work waiting for this moment. You know, we've worked with IDEG on many different things, local government reform, trying to get MMDCs elected and all of that. So we are glad that with this process, they have become very good allies with the committee in trying to review this document and see what we can make of it. So they want to make a presentation to us. Unfortunately, it doesn't come with a check, but it's more paper, and we will take it, you know, because we know silver and gold have you none.